May I please, Your Lordship? Lordship, owing to the prevailing situation at Delhi, my senior counsel for respondent 11 in the item 3 of today's list, he could not appear before the Honorable Court today, owing to the internet disruptions.
Lordship, if I may allow to something, Lordship, this matter is pertains to an elephant, Lordship, who is in captivity in Tamil Nadu, Your Lordship. It's a matter pertains to an elephant, Lordship, named Joymala. This is a captivity in Tamil Nadu, Lordship.
Yes, I remember.
Illegally, Lordship. That is also illegally, Lordship. I am for the respondent number 8, that is an NGO, PITA, Lordship. So my only concern is that regarding the welfare of the elephant, Your Lordship. There are other rehabilitation centers in Karnataka. She can be sent to their Lordship, and thereafter, Lordship, the matter may be keep on going on, Lordship.
So far as below welfare is concerned, every 3 months, medical team is looking after the elephant. Medical reports are there. Since last 2 years, regularly we have been filing medical reports. And on each occasion, my learned friend comes out with this plea that elephant is in trouble. Elephant is absolutely hale and hearty and very healthy in fact.
Lordship, they are saying that, Lordship, but there are records, Lordship, which will show that the elephant has been tortured, Your Lordship, in the past.
Records are silent, sir. You could not file any affidavit on that.
Lordship, because I am not allowed to go inside the temple, Lordship.
You are making,
State has already
you are
visited.
making submission on what basis, Mr. Counsel?
Lordship, I have filed FIRs, Your Lordship, in the police station, Lordship.
Understood. My
my-
question is, your submission that the elephant is tortured. On what basis?
Lordship, I'll show you records, Lordship. It may, Lordship, take up the matter, Your Lordship. I've given our investigation report, Lordship, where they have used weapons like Amkul and all to hit the elephant, Your Lordship. I've shown, Lordship, by photographs.
There was a newspaper report, my lord. There was a newspaper report. Matter came before Justice Manish Chaudhary. Justice Chaudhary suggested in that case you file an affidavit. We simply can't go by the newspaper report. They didn't file any affidavit.
We'll see when the matter
Lordship, in
reaches.
that regard, I filed an affidavit, Lordship, where I
The
stated.
council will see when the matter reaches.
Lordship, otherwise in this matter, Lordship, we are for the petitioner. We have filed,
When the matter reaches.
Lordship, but Lordship, one affidavit has to be filed, which. Lordship.
Where is Mr. Doctor?
He's coming, man. He has requested that the matter may start. He's coming. My lord, just to refresh,
Yes.
this the petitioners herein are aggrieved by the sudden enhancement of the betterment fee, which we thought to be tax initially, but subsequently now it has been clarified that it is not tax, it is fee. So we came to know about this enhancement from the publication in a local daily, and the gist of all this enhancement are given in paragraph 7, page 13 of my writ petition. And the main grievance is in respect of the water tax, which has been enhanced from rupees 125 to 300 rupees. Along with that, there are certain other enhancements. Now, we approached the municipal authority, that is the executive officer who was in the helm of affairs of the board at that point of time. Now, my lord, we eventually could come to gather from the affidavit filed by the municipal board. And in their affidavit in page number 119, they have annexed one. They have annexed one notice dated 21st February 2024, which says that this is the annual budget of the municipal board, which is sought to be scrutinized by the people of the municipal area. And to that extent, the copy of the budget estimate was hung up in the office notice board, and the people of the municipal area were given 7 days time to do necessary inspection and come up with their objection, suggestion, etc. Now, we have responded to this affidavit saying that this is well nigh impossible because, first of all, the notice has been circulated in a manner which is not prescribed, or rather which is in not in consistency with the provisions of section 79(2) of the Municipal Act, which says that publication has to be understood as circulating the notice in two local newspapers, one in English, other in
Other
vernacular.
elections have happened.
No. Even that matter is fixed tomorrow, wherein they had filed, the Election Commission had filed an affidavit saying that within 2 months of the assembly election, they will conduct the election in the municipal board. But till date, election has not been held. That matter is fixed tomorrow before the Honorable Court number 5. Now, my lord, here the affidavits which were filed by the municipal board, in fact, could not substantiate the fact that the notice was in accordance with either section 79(2) or section 68 of the Municipal Act. And insofar as their decision to enhance the fee is concerned, now that they have come up with their stand that this is not tax, rather it's a fee, and there is a quid pro quo element involved. Now, to that extent also, your lordship had put a query before the government as well as the municipal board as to whether, in adherence to section 301 of 301 of the Assam Municipal Act 1956, whether there is any rule, whether there are any rules framed by the government empowering the Assam Municipal Act to enhance the fee. Now, the government has filed an affidavit making a categorical statement that apart from the sections, that is section 68 and section 148 within the Assam Municipal Act, there is no other rules framed by the government empowering the municipal board to.
My question was not for empowering the municipal board is empowered by the
Act itself. Procedure.
So my question was, named any rules in terms
Mal.
of section 3012
Mal.
as to whether any rules have been framed stipulating the procedure?
Mal.
Because if there is any other procedure, then the procedure would have to be gone into.
Mal.
Otherwise, it has to be in terms with the notification, that has to be in terms with 79.
Two. Section 79(2), publish is the word that is defined. And since we are into fee and not into tax, so we are, for the time being, my lord, not going into section 79F, which stipulates that the enhancement has to be after every 5 years. And thereafter there has to be, but then the word publish has been defined under section 79 clause 2. Now here, my lord, pursuant to the query by this honorable court, the state has the director of municipal administration has filed the affidavit categorically stating that apart from these sections, there is no rules framed by the government for establishing the procedure for enhancement of fee. Now it has boiled down to the fact that as to whether in the absence of any such rules, the procedure that was followed by the municipal board in hanging up the notice in the office notice board and allowing the the localites of the municipal area to come up with their objection against the same within 7 days, whether that conforms to the procedure. And if there is no such procedure, then in that case, whether this action on the part of the municipal board, whether that sustains. Now, to that extent, my lord, I have been able to gather some authorities of our honorable court. One is an old one. This is Aurora Cinema and another versus State of Assam, 1981, 1 GLR 315. If I may be allowed to read from my lord, the second, third page, that is page number 318, the last paragraph onwards. The last paragraph onwards. The authority of the municipality to impose the fee has not been disputed, but according to the learned advocate for the petitioners, the exercise of power by the municipality is subject to the condition precedent of existing rules. The answer to this question, I think, will be found from the provisions of Section 301, which empowers the state government to frame such rules. In the instant case, the enhanced license fee has been approved of by the government and there is no dispute regarding such approval. This being the situation, the imposition cannot be subjected to any challenge because if there be power to impose the license and if there be approval of the rule making authority, the validity of the fee cannot be questioned. The rule making authority, namely the state government, by its executive orders can fill up the gap left by any rule or rules. Moreover, the executive power of the government extends to all matters regarding which the legislature of the state has power to make law under Article 162 of the Constitution, subject to the executive power conferred by the Constitution or any other law. My lord, then, my lord, your lordship will come to the paragraph down below. Hence, when approval of the government in exercise of its executive power has been accorded to the proposal of a tax or fee to be imposed by the municipality, which has power to impose it under the Act, absence of rules regarding the conditions of the tax or fee cannot be a cause for invalidating such imposition under Section 68(1)(2). The municipality can impose with the sanction of the state government any other tax or fee, etc., besides those enumerated under the section. The question whether the municipality can revise the enhance the rate of the fee can be answered by the proposition that there is the provision of renewal of license. As there are provisions of renewal and imposition, such powers must be taken to include the powers to revise and enhance the rates. On the question of the possibility of unbridled exercise of such powers by the municipality, there is certainly a check in the form of the requirement of approval by the government. Learned counsel for the petitioners addressed at the bar that under Section 68 and Section 230 of Act, those powers can be exercised by the board at its meeting. An executive power of the municipality in supersession cannot impose any fee, even with the approval of the government. But in the case of supersession, the executive officer or the administrator appointed under the Act exercises all the powers of the board, and hence the argument on behalf of the petitioners has no force. My lord will thereafter, my lord, skip to the next page. Your lordship will kindly see regarding framing of rules at page 321. Regarding framing of rules for the purpose of the Act, it has to be said that such rules are needed for regulating and facilitating the acts under the law. Such a step certainly helps the person affected by the functioning of the authority concerned to know where he stands and how he is to proceed. It also helps keeping the authority exercising powers under the Act within known limits. Here, in the instant case, admittedly, rules have not been framed. The municipality and the government will certainly see that the rules uh, 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 here in the instant case, admittedly, rules have not been framed. No, no, no. Muras. Here in the instant case, admittedly, rules have not been framed. The municipality and the government will certainly see that rules come into existence without further delay. As regards enhancement of fees, the authorities concerned, though they have enough power to revise and enhance the rate of fee from time to time, should see that this is not done in an unreasonable way. Good conscience and equity should not remain strangers even to executive functioning. Justice should form the basis of executive action to be expressed in reasonability. Now, this is, my lord, a ruling which brings into aspect the necessity
Which is
of
in favor of them.
which is in favor of them, but not in an arbitrary or unreasonable way, my lord.
There's no quarrel with that.
My lord,
You don't need a proposition of law
my lord.
to be shown before this, that there cannot be an arbitrary and an unreasonable enhancement of.
My lord.
And on the question of reasonable and arbitrary,
My lord.
here from 125 to 300,
My lord.
taking into account that it is a more of a betterment fee or they are providing those facilities,
My lord.
and it is also required, it is absolutely, in my opinion, to be the subjective satisfaction of the authorities concerned. That is it. Now, it is not a 10 time a year, but it's just in a 2.5 times more than what has been already charged.
My lord.
That is one. I have difficulties when there is a requirement of framing of the rules,
My lord.
and to aid it under 162, there has to be an executive instruction.
My lord.
Maybe it may not be the rule, but if it is the rules or it has to take the place of the rules, then there has to be an executive instructions in lieu of that.
Well,
Now, without there being an executive instruction by the state as to the procedure to be followed, I don't think with due respect to the learned coordinate bench, was right in this regard. That you have the power, the state can approve it, but where's the procedure?
exactly, this has been, my lord, dealt with by our honorable court in a ruling 20 years later in my lord, Selwell Advertising Private Limited versus State of Assam, where my senior was representing the municipal board. May I just place this ruling? Dada.
You give what you want. He can very well need not move around. Yes, what is this?
My lord, this is 2002 GLT 733. Your lordship, my lord, comes to paragraph number 10. Page, this is page number 3, paragraph number 10. The Director, Municipal Administration accorded approval to the budget estimate under Rule 16 of the Municipal Accounts Rules and Budget Estimate framed by the state government under Section 301 of the Assam Municipal Act 1956. The Director, Municipal Administration is a functionary under the Assam Municipal Act. The functions which he may be entitled to discharge may be found under the statute itself or the rules framed thereunder. It appears that under the statutory rules, approval of budget estimate may be one of the functions assigned to him, which the director has discharged accordingly under Rule 16 of the Municipal Accounts Rules and Budget Estimates. Such function provided under the rule was not partake the character and function of an authority, namely state government, as provided under Section 68(1) of the Assam Municipal Act. The nature and character of the two functions is entirely different. Levy of taxes under the law as provided under Section 68(1) of the Assam Municipal Act relates to imposition of tax with power by the state government to sanction the same. No estimated income in the budget would validly be included in the budget estimate unless such tax is validly imposed in accordance with law. In absence of a meeting convened for the purpose, namely for considering the question of imposition of tax under clause N of subsection 1 of section 68 of the Assam Municipal Act, and without there being any such decision of the board, and over and above without any sanction of the government, it cannot be said that any hoarding tax was ever imposed by the municipal board. So far, the position of imposition of a tax under clause N subsection 1 of section 68 is concerned, it stands on a different footing. Clause N does not lay down any particular tax, but a general power for levy of tax on items other than covered under other clauses with the sanction of the state government. Mere existence of such power would not justify realization of any tax by any name for any purpose in respect of which there exists no decision, much less in the manner prescribed. To be a valid tax imposed under clause N, it must have the sanction of the government before it can be realized. But there is none in the present case. Approval of budgetary estimate by the director for the year 75-76 would in no way amount to a tax under clause N of subsection 1 to section 68. The existence of a power to impose tax, the authority empowered must exercise the power. In the present case, the board never seemed to have considered the question of imposition of hoarding tax in any of its meetings conveyed for the purpose, namely for imposition of hoarding tax. The other question arises later is about following the procedure, etc. In the present case, we find that there is no foundation of hoarding tax itself. The director, in discharge of his functions under Rule 16 of the Municipal Accounts Rules and Budget Estimate, had only been discharging his statutory duty, but his powers would be confined only as may be conferred under the provisions of the Act or the rules, and not beyond the provision. Budgetary approval in the estimates showing any income from any kind of tax not imposed by the authority, much less in accordance with law, would in no way subject the people to exigibility to such taxes. Therefore, in our view, the demand of hoarding tax from the petitioner appellant is illegal and is liable to be struck down. Now, here again, my lord,
Here, it gives a it's a very fine distinction
Right.
between the power to impose and on the basis of the exercise of the power to impose, which is already mentioned, budget estimate being prepared, which has thereupon being sanctioned by the government.
absolutely.
So mere sanctioning of the amount by the government would not amount to imposition of the tax.
Yes.
Or in other words, mere sanction of the government of a particular amount to the budget
Well,
would not amount to granting the approval, enhancing the rate of the tax.
well.
That is what you want to bring.
And on top of it, my lord, in this case, what transpires is that there was no meeting by the board in which a decision of this nature was taken and subsequently followed up by the procedure as laid down under the act. In
Because what is required out here is that first the board has to decide.
68, section 68 envisages.
Board has to decide, and in absence of the board, the executive officer would decide.
Mal.
Now, the executive officer decided. Now, thereby to enhance the rate of the fees.
Right.
Once that has been done, it has to follow the procedure.
Procedure.
Now, the procedure is to be laid down as per the rules.
Right.
Neither there is any rules nor any executive instructions.
Right.
So, if their procedure has not been followed,
Right.
the next question is, can that be a part of the budget?
That is what, madam.
And if it cannot be a part of the budget, which is as per this judgment, mere granting the approval by the government of the budget not amount to enhancement.
Absolutely, madam.
That's your submission.
Absolutely. My lord, one ruling, my lord, that was in respect of urban tax, recently decided by your lordship in this Tinsukia Development Corporation case. My lord, here also, my lord, eventually the procedural lapse when it came to publication of the notice for enhancement of the urban tax, that was not there. But your lordship eventually, my lord, was on the point of whether it is a reasonable enhancement or to the satisfaction of and
No, they said it to be reasonable, unreasonable. I said that it is reasonable, taking into account for that since 1975,
Yes.
there was no increase of the tax.
Well,
And as such, it was done only recently pursuant to
appealing
the
of
government's decision, whereby there was a fixation of the holdings. There was as per section 79, F is not
D,
there,
D.
79E.
my lord.
79E was the question,
Right.
that there was no, because what happens is that you have to notify by way of a notification as regards the rules,
Right.
as regards the particular roads to be,
Yes, ma'am.
then has to be stated out there. I
Right.
think as per 79D. So that is what I said. But I interfered with
The urban
only
tax.
to the extent that there has been no publication as
Yes,
regards
yes.
79.
Yes, my lord, I have this judgment with me, if your lordship wants to, my lord. This is the by your,
Obviously, I must have forgotten.
this is UPC 7345 of 2023. We have not been reported till now. My lord, we'll see, it is the latest, very recent judgment, my lord. From page 38, my lord, there has been this determination of analysis and determination of this, of the facts involved, my lord. At page 31, from paragraph 38 onwards.
Now here I went into another question. The respondent board, in view of the repealing of the Assam Urban,
Yes.
so and so cannot impose the urban tax.
Well,
Now there was a repealing done.
yes.
So therefore, at that point of time, they could not have imposed the urban tax.
Yes. And if
Therefore, it is, however, clear the impugned notification imposing holding tax at the rate of 3% is not interfered. So it is only on that aspect.
On the
like
repealing aspect, your lordship had in fact struck down the notification. My lord.
to other aspects. Here, the judgment of the division bench
My lord.
relevance taking into
Well.
account that the power to impose is
Well.
different from the power to put it out there in the budget estimate.
Well.
So there has to be a tax first, and thereupon you can insert it in the budget estimate.
Absolutely. my lord.
Your case is that you have inserted in the budget estimate. You put it in the budget estimate without first imposing it as per law.
Absolutely.
That's your case. Anything more?
My lord, I'll confine to this only.
Yes, Mr. Datta.
My lord, as your lordships has seen that in terms of section 301, government is required to enact certain rule in regard to that. But that rule has not been framed. Now, my lord, the moot question would be, now this is a procedural part. Now, if this is not there, in that case, what we are doing? Now, when the budget is approved by the appropriate authority.
That is what the the division bench say.
Yes.
Merely approval of the budget by the government would not amount to a concurrence by the government unless first there is already a concurrence of the government
Yes.
of the imposition.
Right. No, here the problem will be, my lord, it will go against the public, supposing on the basis of that.
The main problem out here is that you have put the notice board in your office.
That we are doing that, but rightly your lordship has,
That needs to be done something.
in accordance
You
with
need
law.
to publish it in the newspaper. That is the publication which is mentioned out there in section 79. Yes, they have not provided the rules, it's okay. But adequate publication is required so that the people can object.
To that extent, I'm with your lordship, my lord. This is a
That
very
is the
right
only
position.
problem. Now the question is, should this court interfere with it, with the
Lord,
enhancement?
I,
Now,
I don't think your lordship will do that. Otherwise, what will happen, my lord?
no,
the
otherwise
larger
what will
ramification.
happen is different, but the question is, should this court interfere with it, taking into account that you have not followed the procedure?
Now,
As of now,
right.
if we go by the judgment of the division bench, you see, you have not increased it. Increase or accepted the renewal, the increase of the amount have not yet till date happened as per law. You are basing yourself on the basis of the budget.
Yes.
Now, if you are basing yourself on the budget and the approval being granted by the state, then your very imposition would be bad.
You know, it is in compliance of section 68 of the Assam Municipal Act.
No. That is what the division bench judgment is. The problem arises because of that. You have the power to enhance. There's no quarrel.
Yes.
But first you have to enhance, then to put it in the budget. What you are saying is, we have put it in the budget.
My lord, we have
And that has
enhanced,
been affirmed by the government.
we have enhanced it, then we
Where?
put it in the budget. Now that your lordship.
So
has to say.
where is the government's approval prior to putting it in the budget?
That is, my lord, your lordship, if I take your lordships to that. Your lordship, kindly see at page 163. At page,
Yes.
at page 178. This is the tap rate charge
Ah.
of rupees 300.
Huh?
Page 178.
What is this document? This
This
is the
doc-
budget.
This is the budget.
No, therefore my question is, Mr. Datta, this is the budget. So how can you put it in the budget without first getting an enhancement approved by the government? That is the judgment of the division bench. You have a copy?
Well,
No, that I don't have.
Give it to
Well,
Mr. You knew about this thing. You were the person who has appeared.
Now that, in that case, I.
And it is your municipal board who has suffered.
No, here in this case, my lord,
Paragraph
it is,
10.
if your lordship look at page 192, that budget approval was there.
That is what I'm saying. You could not have put it in the budget unless you had the enhancement approval.
Your lordship want to say that it should have been done much earlier.
Prior to that, then you put it in the budget.
That.
Today, it is
difficulty-
something, it's a very simple example which is there. You today don't increase your rates of tax. You don't increase your rate. Can you put in your budget that this is the amount we are going to get it from that amount? This is what has happened.
My lord, if your lordship
First,
see
you have
the,
to increase the tax. We have to increasing this tax. And then you say, yes, this is the amount we are going to get it. And from there, we are going to spend it in such manner.
my lord, before the budget, my lord, the director used to send us a letter that if you want to make any budgetary enhancement, then you make it in your budget, you send it to us. If we approve,
Now, I would have understood that Kharupatia Municipal Board saying that making that submission. But can the Silchar Municipal Board make a submission to that effect when the law is very clear in respect to another judgment where the Silchar Municipal Board has suffered? So you cannot base yourself on what the director writes. You have to base yourself on the basis of which you have to first enhance it, that we want to enhance this amount so and so, and therefore we need the approval. And that enhancement is subject to giving a notice to the people concerned who are going to suffer. And this notice has not been issued. You put it out there in the notice board. And here the publication has to be done as per section 79.
but 79 is not relating to the betterment fee, my lord. If your lordship kindly look to that, that is in regard to the property tax. Can I take your lordship to that?
Let us see what is the concept of betterment fee.
Yes, at 68, my lord.
Okay.
Section 68,
Section?
68 E.
Section 60. Yes.
K, my lord.
A betterment fee on the holdings in any area which value has increased due to improvement so and so. Now, have you increased the value of the holdings?
Now, what happens, my lord, when there is a scheme like Amrut, Swaraj Board, these are the schemes.
No. My question is, have you increased the holding which has been done in Tinsukia?
No, for increase of holding in the sense, my lord, if we develop the scheme, they're getting the betterment fee is taken for that purpose. Because we are not taking tax, my lord. When there is a corresponding increase,
And it is completed at the board's cost.
yes.
No, it is given by the government.
No, government hasn't granted any scheme, my lord. Amrut scheme is there, but they have given a little amount of fund, not the entire fund. Now it is in the even
So
the
it
beginning
will be
stage.
it will be there in your budget in any of your documents.
No, my lord. So that
If the
document is
moment you
there.
are putting it as a betterment fee, it has to be on black and white.
Yes,
So where is it?
that will be on record, my lord.
So you must have done it out there. You must have put it out here in your affidavit. Let us see where you have
Yes,
put it.
that we
That you have increased it.
in our affidavit, your lordship will find that. Your lordship may see at page 153. An additional affidavit at page 154. Para 4, your lordship.
You are not charging the water tax.
No, we are not charging water tax.
So you are charging it in the name of betterment fee. How? How can there be a betterment fee over a tax which is not being charged?
Tax, my lord, if we charge, it will be huge amount, my lord. If your lordship look at how it is
To bring in
calculated.
264. 264 is for providing the electricity, the water supply.
Right.
Now, once you supply water supply, because of that, a water tax is permitted under section 68.
68 tax as well as the betterment fee, both the. portions.
Understood. But
Yes.
water tax is there specific. Now, if you are relating to the service which you are being provided under 264, then can you say that it is not to be we are not charging water tax, but we are changing a betterment fee? Betterment fee over what?
Betterment fee, my lord, the cost incurred there, in order to realize that amount only we get it from the.
So you are not charging water tax, but you are charging a water tap charge.
Tap fees. Otherwise, my lord, your lordship kindly say 79. If we charge that, it will be huge one, and we don't think there will be any collection of amount that way.
Yes, what is
Lordship
that?
kindly see at page clause 79, section 79.
Yes.
And that we have clarified in our affidavit also.
What is it?
Your lordship kindly see 79, determination of annual value of holding. Public note, okay. And how it is, my lord, assessed at 79D, rate of tax. Hmm?
You show me the provision by which you can increase the rate of tax. You have the power to impose. How do you increase?
Rate of tax 79D, your lordship will find.
So therefore, if we are referring to D,
Yes.
rate of tax, tax shall be assessed on the value of the annual rental at the following rates. Holding tax, water tax subject to the provisions of a month at the rate of 2% of the annual rental value other than the user tax. So therefore, the water tax or any tax has to have a correlation with the annual rental value.
Yes.
Now, have you increased the rental value?
No, my lord, if we go to assess under that,
Ah.
my lord, the
That
valuation
I'm
will
not
be,
concerned. No, Mr. Answer. Merely because of the fact that the rate will go up. That is immaterial of the question. That has nothing to do. But you have to do it. Where is your power to increase the rate?
increase, my lord, it's not a tax, therefore, betterment fee.
No. The tax is there, but
Yes.
how do you increase the rates?
Increase, my lord, when the cost of material increases, say supposing
So
bleaching.
therefore, the cost of material increases has to be done with the annual rental value. Now, if the annual rental value have not been increased, can you increase the rate?
My lord, annual rental value will increase every year. Supposing, my lord, even otherwise.
No, it would not. Every 5 years it will increase because there is a the act categorically mentions that every 5 years there is a freeze.
If it is 79, if it is section 79 is.
No. You therefore you are saying that don't look into 79 on one hand, and on the other hand you see that again you are tracing back to 79. So where is the power to increase?
No, power to increase.
Because
relates back to-
68 does not give you the power to increase. 68 empowers you to the power to levy.
Yes.
Where is the power to increase?
It case is betterment fee can be levied.
Understood. My
Now-
question is, how do you increase if you have a betterment fee? You see, the thing is like this. Either you have a betterment fee or you are putting the betterment fee for the first time.
So it has been since 2014.
So if you are there, then where is your power to increase?
Increase below every, supposing the any cost of the materials, every day it's increasing.
No,
Now, bleaching for
Mr.
what
Mr.
is,
Datta, you are not understanding my point. The power of increase has to be there.
it is inbuilt under 68K.
Where?
68K.
Let us
Now,
look
when
into it.
that power of levy is there,
Ah.
and if we want to increase, supposing when the cost of material increases, automatically, my lord, we'll have to
No.
get
The
that
power
amount.
has to be given. The power to increase has to be there. You cannot bring in the General Clauses Act. The power of increase has to be given somewhere. Where is the power to increase? And if you are relating it to Section 79, it has to have a correlation with the enhancement of the annual rateable value.
We are not relying on 79 at all
So
because
if you are
we're
not
not
relying on 79, where is their power to increase under 68?
68, my lord, that is the power because when we have the power to levy, automatically, my lord, that power, it is inbuilt power in 68 itself to increase well, there is a corresponding increase in the raw material.
Where is it? Show me a judgment on that. That even irrespective of the power being granted by the act, there can be an increase. Show me that.
My lord, otherwise, what will happen?
Otherwise, all acts provide so. Here, the mechanism is based upon the annual rental value. The once the annual rental value increases, correspondingly, the tax which is there or the fee which is there automatically increases. So therefore, you cannot keep the annual rental value stagnant and on the other hand, increase another aspects. The very idea,
that-
kindly see section 68A.
Yes.
A tax on holdings situated within the municipality assessed on the annual value payable by the owner.
Yes.
That is one. A water tax payable by the owner or occupier on the annual value of the holdings.
Yes.
A lighting tax payable by the owner or the occupier on the annual value of the holding. All these are there.
Yes.
Till E. Till D. A drainage tax payable where a system of drainage is there. A tax on private markets payable by the owner. So these are different. These have nothing to do with the house. Now kindly see K. A betterment fee on the holding in an area which the value has increased due to the improved schemes completed at the board's cost.
Yes.
So therefore,
That is what I'm saying, my lord. When there is a scheme,
you have done it. A betterment fee, you can impose it. But how do you impose it? How do you increase the betterment fee?
my lord, otherwise, my lord, this provision will be almost saying that it is otious.
No, you can very well to take into account the betterment. You can impose a betterment fee. You can
Yes.
increase the betterment fee. But you are not using it as a betterment fee. You are saying as a water tap charge. Now, when the writ petition has been filed, now you have brought it into the ambit as it is a betterment fee.
Your lordship kindly see, we have the material also. Your lordship kindly see at page 159. This is the office memorandum dated 6/5/2014.
Yes.
The Silchar Municipal Board in a board meeting passed annual budget estimate for the year.
Daily collections, it would be more practicable that the tax Karaga shall now onwards write his cash book as per computerized format here. Similarly, above the board made alteration of the Beya to be termed as other as any change in the head of the account made available with the budget document may be required to be followed, all so and so. This was done in so and so. Will be adopted NIG of so and so based on double entry accounting system for the years when. No, you are imposing water tax at page 168, serial number 4.
Your lordship is referring?
168, page
Water
160.
160.
160.
You are charging on water tax on residential holdings. 168 page.
Is. Mhm.
Are you not?
From this it appears, my lord, there also
For residential buildings,
Imposing-
your holdings, you are taking water tax.
79D.
Yes, we are already charging it. Then kindly come to 176, serial number 91. Now kindly come to 178, serial number 105. Betterment
105.
fee rupees 300 per tap charge.
Yes.
Earlier you were getting 20 lakhs something, 2 crores. 2 crores for
2 crores, 4 lakhs, 44.
44,000.
Yes.
Then budget estimate for the current year, 2023-24.
1 crore 79 lakhs something.
Huh?
1 crore 79 lakhs
79 lakhs.
41,000.
As budget estimate 5 lakhs. Budget estimate for the year 2024-25 is 57 lakhs. So you have increased here for the first time.
5 crore 76 lakhs.
So
Budget
you have to increase it on, how do you increase it?
My lord, this water tax. Water tax, my lord, if we look at 79,
No, you have already taken up water tax.
sometimes I've seen that it is,
You have already taken it up
Yes.
as water tax. There is no quarrel of that. You initially said that there is no water tax. Kindly see this at serial number 4.
serial number
Water
4.
tax you are saying actual for the previous year 2022-23 is 92 lakh 16,000. Then budget estimate for the current year, which is 1 crore 78 lakhs. Then budget estimate 23-24. It is so and so. And the next one is 2 crores.
2 crores.
So here you have to budget estimate for year for water tax revenue, you are already getting 2 crores. So here there is already an increase.
Now it is 5 crore 76 lakhs and odd.
That is for the purpose of betterment fee. So now betterment fee, you have increased it by 300 rupees, irrespective of water tax being there. And therefore, the amount which was earlier 2 crores or something, now it has now become 5 crores.
5 crores.
So therefore, you have done it by 300 rupees, you have enhanced it. My question is, where do you get the power to enhance? Power has to be there somewhere. Merely the power to impose does not give you the power to enhance. And if you have the power to enhance, then it has to be by way of a procedure. Now, if the procedure is not there, that the rule have not been paid, and you say that 79 will be there, it would automatically be an arbitrary exercise.
Now, on the other hand, my lord, what your lordship is saying is quite okay in absence of the rule-making power of the government.
For example, let me tell you about this thing. When Assam's General Sales Tax Act came in 1993, they started deducting tax under Section 27. There was no rules. Without the rules being framed, it was the rules, if you see, the Assam General Sales Tax rules came in the year 1995. Section 27 was held that it was ultra-virus, that you cannot impose unless and until you have the prescription. Now here is a case. You say that 79 would not come in. You can increase at your own will whenever you feel like. Means 79 puts an embargo that there is a freeze for 5 years. So you say the 79 would not come into the picture. There is no power to impose is given, but power to enhance is where? And would the power to impose only permit, if you imply the General Clauses Act, would the power to impose will also encompass the power to enhance? And if it is so, can it be done without there being a prescription?
But if I take your lordships to our affidavit, what is the position at this stage, my lord? Your lordships, we are incurring loss of 15 crores annually.
Well, Mr. Doctor, there is no question, quarrel that you need this. Therefore, I said to him that on the subjective satisfaction, this court is not going to enter. As to whether it should be 125 or 300, I am not. You may require it. But for that, are you saying that we live in a country or live in a state or in Silchar, the rule of law or nothing follows?
Now, on the other hand, my lord, let us
But the one fine morning, the executive officer thinks, yes, the budget, look here, we are not able to run it. So let us impose, enhance the betterment fee to whatever level he thinks so. Because now you don't have a board. Now, in absence of the board, it is the executive officer who is exercising the powers on his own.
Now, my lord, the commissioner it is now is my lord corporation, so therefore commissioner is there.
Maybe. So he does it on his own. So the executive officer done is on his own that this is my calculation and as such we should enhance it. Since the budget, the government approves it. Would that amount to enhancement? Where's the power to enhance?
Your lordship is right in questioning that, but then the commissioner has determined to increase it because of certain reasons.
Understood. You may have good reasons, but can you do it?
My lord, this
Today,
is
the government has very good reasons to say that we need the reserve forest clear. There's no quarrel with that. The reserve forest, no person should be inside there. Government has good intention that over here. But can the government tomorrow go there and just throw these people out?
there is a
No.
procedure.
There has to be some procedure to be followed. Now here is a case where no procedure has been followed.
My lord, the source of revenue of the municipal commission. Now, the source of revenue is stopped now. What will the ramification? Your lordship, just for a while, visualize that position. Now, if there is no revenue, my lord, we shall have to stop the supplying of water to the residents. Now, there will be total anarchy, my lord.
Then also you need
Because
to.
unless we
No,
have the fund.
There might be anarchy, no anarchy, that is a different thing. But then also, don't you think that the law has to be
No, no,
followed?
that's right. Very right, my lord. There should
Tomorrow
be a
you
law.
may say, okay, this is not there. Any person eating food on the road or any person smoking outside anywhere, we are going to impose a tax of 1 lakh.
No,
You may
is
just say so.
the arbitrary way.
No,
my
it
lord.
may not be arbitrary, taking into account that the smoking is a public hazard. You may so. Yes, it is rightly. I am a judge out here. I may say, that, yes, right. It is so. But can you do so? No. The law has to be there. You have to have the backing.
Now, the state has to, my lord, formulate the law, they are not doing. But somehow, my lord, it's not that we are not giving them any chance. There was a need of
No, your
enhancement.
chance was, Mr. We cannot, this court cannot approve your chance. How you have given the chance? I think something has to be done. We need to, I won't interfere with this 300 increase, but I say that within 4 months, you need to complete an exercise by which giving notice, hearing them, and thereupon going ahead.
Well, that can be done, my lord. There won't be any problem.
So that then you have to decide on their objections as to whether the rate of 300 increase was right or not. Thereupon you do it. As of now, the question of refund does not arise because the money we applied Mafatla judgment and we say that no. But we need to correct your measures.
That's absolutely, my lord. That
This is the only way out. Because their grievance is that they don't have any say out there. You do it arbitrarily. Yes. The moment you say, you are saying that the rate of this 1 lakh imposition as a smoking hazard is arbitrary. A rate which is being increased without giving an opportunity to the people is also an arbitrary exercise. There's no quarrel with that proposition.
that is
They haven't
somewhat.
say they are the person who are going to pay. Should hear them. I
And-
think that is there. That appears to be a fair resolution of the dispute.
And
I think that this is wrong.
very interestingly, your lordship kindly see, in this case, they are paying. All the taxpayers, they are paying.
You see,
There's no
More-
grievance at all.
let me give you an example. The Income Tax Act has come in 2025. As per this imposition which is being made, you have to pay. There might be somebody who will be challenging merely because of the fact that you are paying and the other person challenging it, his challenge should be nullified.
No,
No.
that can't. be.
So that is your submission. That is the answer to your
No,
submission.
and your lordship kindly see, who are these people? They
I'm not
have
going
some
to stay
political
on that.
ambitious.
These are citizens. Are you saying that they are not person who are residents within the municipality?
They are the residents of
Matter over there.
some advocates, some engineers, they have come with some other.
Advocates are not human beings.
No, they are with some other intention, my lord.
So what? Their intentions may be many, but that is a law.
No, What,
Yeah,
why
I
I'm
don't,
saying,
Mr. Doctor, I would not see out them as some, if they have made out of a fair point has to be taken into
no,
consideration,
truly,
whoever it is.
I-
Unless they have abused the process. I don't think there is any abusing the process. We do one thing. We interfere with this imposition, but not, there's no question of refund. Asking you to issue a public notice, giving due opportunity, and then thereupon decide what is the rate should have on the basis of their objections. And then whatever you have taken, you take it. And thereupon, for the next 4 months, this would be the rate which will continue. Thereafter, you will decide. You don't have a clear ticket that beyond 4 months you can keep on holding this, unless you come up with a justified order to the effect that, look here, after taking the objections and all these things, this is the rate should be 300 is right, or maybe less, but not more, because you cannot have it more, because there is a freeze of 5 years. That appears to be more reasonable.
balancing the equality.
That seems to be more reasonable.
Only thing, my lord, your lordship is not interfering with the enhancement, but your lordship will make an observation, my lord, that 300 would be subject to the outcome of the.
Oh, yes.
Yeah.
So they can not increase more than 300 for this period from the date, because there is a cap of 5 years.
Right.
So below that, they can do.
Fair enough.
Anything else, Mr. Doctor?
Well, can I take your lordships to section, my lord? No. 68, no. My lord, 68. 6, my lord.
Huh?
68-6
6? I don't have 6.
at page 56. The power
Completely
of
into the power under
power of municipal
148.
board.
The power is the power. The board has the power to levy rent, so and so, animal, and the power under 148 is an independent and separate conferred by the legislature on the bills at the time when they are in place in respect of the municipal. No conflict between the provisions of section 148. If the section 148 covers entire field of power to levy tax in a year, there was no purpose of it. I don't understand what. Rent, pool and fees. This is for markets.
My lord, they have said section 48 and 68 of the act.
48 is nothing. That is 68 and 148.
148 in relating to market.
So therefore, that was the case by Lohit Chandra Soikia versus not Lakhimpur.
Yes.
This is pertaining to a market. That if you have the power under 68, then you cannot exercise the power. 48. Or 148, if you have the exercise, you have the power, then you cannot on the very aspect and exercise the power under 60. That is on the question. Then here the court must have said out there that looking into account that the legislature have taught it. So therefore, there is no requirement. It is only for market. We are not concerned with
But
that.
she happens to be from North Lakhimpur. Therefore, she has told me to refer it. Possibly, she is from North Lakhimpur. Therefore, she is.
No, I think this is the. Now, this power is to expose goods for sale in municipal market.
Yes.
It has to be in the municipal market, not for any other market. We have the GMC market out here,
Right.
although it is different. Because if you see 68, license for cards, a fee, this is not, the power has not been given here for markets.
Yes.
So therefore, for markets. they are
Market
having a
one
different-
48.
But would the power to levy include the power to enhance?
My lord, in my respectful submission,
No,
this is
don't make
inbuilt.
submission just for the sake of it. Are you backed by any law? Because of the fact that then you put the burden on me to search for law. Author. The power to levy, because you see, there's another thing. The moment I give that direction, I will be shutting my eyes to the fact that as to whether they have the power to increase. The moment I give it, then someday, some junior who hails from Silchar may assist another person who appears on behalf of Silchar Municipal Board at some point of time. Look here, this court have done it and looked it and done it. Because you see, the betterment fee, we do one thing. You produce the records. Yes. It's not here. Produce the
Records of, my lord,
records of the increase.
Increase.
But how you increase. Produce. Because with that, I will get an idea. In the meantime, you find out whether the power, because yes, what happens is this. If you go by the Municipal Act, more particularly, kindly see this. This provision is very interesting provision. When I was doing the Tinsukia Municipal Board matter, Section 78A5. Now, you see, this is a very interesting provision. Subject to the approval and of the following committee, a municipality may from time to time publish the list of principal main roads and the main roads, and if necessary modify the list as may be decided by the committee. Now, once that is being done, just for example, a road, for example, the road in front of this high court was not the principal main road, but the moment the principal main road is being given, the rateable value of the holding increases. Once the rateable value of the holding increases, the increase will be correspondingly to the tax.
Road tax.
So that tax is there. Now, in the name of, now I think there is some place somewhere, if I'm not wrong, or there is some judgment, you cannot increase the rate of tax to a particular level. So here the basic idea is on the basis of the holding. Moment the holding is increased, what happened in Tinsukia Municipal? They increase the holdings. And once the holding is increased, the 3% the tax which was there or any tax which was there automatically increased. And therefore, if you see section 68, 68 is on the basis of the holding when it relates to a residential holding.
Right.
And if you see 68A, which is referring to a betterment fee on the more provisions or anything provided in the holding. So it has to have a corresponding link with the holding.
Holding, yes.
So here the basic concept is increase in the holding. You see the rate of tax, 79D. Power to fix the rental value and the annual rental. The rate of tax so and so shall be fixed by the board for the Iman at the meeting which prior approval. The annual area shall be committed at the multiple of the carpet area so and so. The rental value rate so and so for different classes and so. Method of calculation, room, how it is to be done. Then rate of tax. The tax shall be assessed on the basis of the annual rental value of the year. Holding tax, water tax, so and so. At a rate of 2% of a year. So they cannot increase the water tax beyond 2%. So what they do, they increase only that particular portion. annual rental value. The moment it was 100, it has become 200. The 2% will now become 6 rupees. Or 300, it becomes 6 rupees. So this is how it is being done. Lettering tax is there at a rate of 2%. So this, the legislature has fixed it. You cannot increase more than 2%. But what the power has been given is for the purpose of betterment. Yes, there is a betterment, so increase the rate. Or 68A also has a touch on the holding, on the betterment of the holding. So what is there, and therefore it is a fee. So what is the betterment has to be a quid pro quo, because it is used as the fee.
Yes.
Proposition of law. So this, if you have increased it, then it has to be quid pro quo. If you go by that, it has to go as per the exactly what betterment has happened, and correspondingly this has happened. So the records will show as to what is the betterment which they are proposing and how it has happened and according. So that power has to be looked. But can you increase this? So therefore, the power is being given. Therefore, there is no mention out here for increasing. Power to levy is being given, but there is no power to given for the purpose of increase. Because if you see all other acts, the power of increase is being given at such rate as may be prescribed, in the manner prescribed. We see all the sales tax act, all these act, it is being categorically mentioned where the tax is, how it is to be increased. So therefore, it produces the rules. But eventually, this is the order I'm going to pass, provided I'm satisfied with those. Then I don't think you will be in trouble. But for future, you'll be more in a year.
Yes. Streamlining the thing.
It has to be streamlined. Otherwise, it will. And asking the government to frame the rules or asking them to frame the rules is just telling something that you do something, and that is never going to happen. So I don't have the habit of issuance of useless writ. Isn't it? It's next to impossible.
Even that part, the municipality can take care of. My lord, publishing in the newspaper, that they can do.
No, so you see, their basic idea is you have to be fair. Give an opportunity to them to say. We don't interfere because this will have an effect upon the entire, what you call, the service which you are providing.
Yes.
It may have. And for the writ court to interfere on that aspect may not be proper. But I put the buck onto you and ask you to do it, but provide the records, because this aspect as to how the betterment fee can be increased needs to be looked into. In the meantime, you just find out.
That there can be enhancement, whether there is a power of enhancement.
The power of enhancement is not there, as we can see. It has to be related to the annual rental value. And this is what has happened out there in Tinsukia. The Tinsukia, what they did, and there were various notifications issued for increasing the rent. If I remember here, if you see the
Yes.
judgment of there, I've quoted it.
Better.
Kindly see this.
अभी लिख लो 7 3 4 5
This is for annual rental value. Where do I put it out there?
No, I'm not move this one.
Heard Mr. D. Chakraborty,
My
the
lord,
learned
this is a
counsel appeared-
complimentary copy for
Huh?
This is a complimentary copy for me. This one.
This one. He has given me the copy, so it is he who has to give you the permission, not me.
I'll
Mr.
supply
D.
to.
Chakraborty, the learned counsel appearing on behalf of the petitioner, Mr. S. Datta, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 6. This court have heard the repetition in detail. Just keep it. Upon hearing, a question have arisen as to whether the Silchar Municipal Board, or for that matter, the executive officer of the Silchar Municipal Board, authority to increase the betterment fee or the rate of tax without a corresponding increase to the annual rental value. In addition to that, a question also arises as to whether the Assam Municipal Act 1956 provides a power upon the municipal body increase the rate of tax on its own without on its own. On its own, for the power to enhance the betterment fee or tax. In as much as this aspect needs to be further deliberated upon. In as much as deliberated upon by looking into the principles as to whether the power to impose will also include the power to enhance. This could also taking into account the stand which have been taken by the Tinsukia Municipal Board the tap rate charge is nothing but a betterment fee. Would like to peruse the records on the basis of which the betterment fee was increased. Mr. List this matter again on 27th?
Well.
Oh, no, 27 is too far off. On 13th, 11th August. You get the records.
11th August.
August. On 11th of August 2026, records be produced by Miss So-and-so, assisting by Mr. S. Dotto, the learned senior counsel.
Records relating to enhancement of betterment.
I've already mentioned the records will be. What are the records? Which, the betterment fee last month. The records will show. I've said all right.
My lord, somewhere there is, I think, Tinsukia Municipal Board mentioned. It has to be Silchar Municipal. Apply.
Eight pillars. This matter has been taken from us, Lordship. This matter has been taken from us, Lordship. New set of bank council will be engaged, Lordship.
I've asked the affidavit to be filed by the respondent.
May it please your lordship? Lordship, in this matter,
Petitioner have to file an affidavit.
lordship, we have been newly engaged in this matter yesterday.
That hardly
Lordship,
matters. You are asked to file the affidavit.
Lordship, actually, the petitioner, she lives in West Bengal. Due to her children's school, she was unable to come. So Lordship, 10 days time may be granted, Lordship. In the
Oh, yeah,
meanwhile,
ma'am.
we will file it,
This
Lordship.
is a serious thing which I'm going to take it up.
Lordship, we have not even received the brief in entirety, Lordship. So Lordship may kindly consider, Lordship. 10 days time may be granted, Lordship. Lordship, my senior is out of station. He will be leading me in this case, Mr. H.K. Das.
Who is your senior?
Mr. H.K. Das, Senior Advocate H.K. Das, Lordship. Some matters are listed before the Itanagar High Court, Lordship, today.
To what?
So Lordship, may kindly 10 days time, Lordship.
Judgment on senior counsel.
Lordship, because we have not received the brief in entirety. That is,
You are
Lordship.
supposed to file the affidavit.
Lordship, we will file it within 10 days, Lordship.
No, you
Lordship,
can't.
kindly consider,
I
Lordship.
have given 1 month.
Lordship, may kindly because
This is a
Lordship.
case where I have asked for a specific instruction
Yes, Lordship.
as to whether you have received this amount. And
Lord-
if you have received the amount, how the writ petition is maintained.
Lordship, I apologize for the delay. Lordship, may kindly consider one last chance may be granted. Lordship, only 10 days time. Within 10 days, Lordship will file the affidavit.
This court, by an order dated 23/6/2026, directed the petitioner in view of the stand which had been taken by the respondents to file an affidavit as to whether the amount of rupees 34,16,668 had been transferred to the petitioner's bank account. Hearing number P1993010444303. And whether the petitioner, upon receipt of the said amount, have taken steps for returning the said amount, back to the respondent number 4. The said affidavit, in spite of a period of almost 1 month being granted, have not been filed. Ms. So-and-so appears on behalf of the petitioner and submits that the said affidavit would be filed within 10 days from today. Submits that she has been recently engaged in the matter. Considering the above, this matter again on course. On 31st of July 2026 at 2 p.m. It is observed that if the petitioner do not file the affidavit, an adverse presumption would be drawn against the petitioner. Only the petitioner would be liable. Petitioner. Not only the writ petition would be dismissed, but also perjury proceedings may also be initiated against the petitioner.
Deeply obliged, Lordship.
Her name may be deleted, Lordship. D. Mohanta and PJ Mohanta. Registry may be directed.
Also submits that their names, that they have withdrawn from their power in the instant proceedings. Their names may be deleted. The registry shall do the need.
Public.
May please, your lordship. Kindly pass over the matter for today only, my lordship.
What is the matter about?
Matter is on the basis of the complaint, my lordship, this writ petition has been filed again for set aside the quashing of the internal committees, proceedings of the internal committee initiated against the petitioner. And recastle the regarding of the respondent number 4 as the
Mr. Chaudhary,
applicant-
you are there in this matter. Last time you saw.
Actually, my lord, that judgment we got it, my lord. Dr. Sohail Malik versus Union of India. But to be honest, my lord, I prepared the brief actually yesterday. I came reached very late, my lord. My lord, in this case, the complainant wants to withdraw the complaint.
That I remember. That is why I asked you.
And secondly, my lord, there was a quashing petition that also has been allowed.
That's a different thing.
Yes.
Quashing is another aspect.
Only thing is, my lord, if the
Here the-
complainant is not
Here
interested.
the person has a, yeah, but don't you think that this person, I have put a specific question to you on the last occasion. That can there be on the basis of a compromise reached later on? Proceedings can be done away with because then it will have a far-reaching consequences
Yes, yes.
on overall everything.
I
Yes,
think, my lord, that
tomorrow,
principle of that in CRPC, some offences are compoundable. If it is not compoundable, then what happens? That is something like that, my lord.
now the question is, here, okay, you may very well, the person, you are the person, she may go away and give a statement that she has nothing to do. That's a different thing. But why should the proceedings be stalled? Let the proceedings go on and then they will drop it. If there is no evidence given by her.
Correct.
So what is there for this court to interfere at this stage?
My lord, may I make one submission, my lord? Let the matter be called next week, my lord. Let me go through this new judgment and make submissions. On next Wednesday, my lord,
Thursday.
Thursday. Come on, next Thursday. Huh? Yeah.
Yes, our full judgment.
Unlike a court report.
I have also delivered one judgment on this aspect.
Relying on Sohail Malik, my lord. Okay, I'll find out.
There, I think, let the ICC, it's ICC, it is called ICC.
ICC.
Internal
Yeah.
Complaint Committee,
Yeah,
internal.
yeah. Because here the scheme is like this, the ICC will look into it,
Yes.
then you have to adduce evidence, and you say that, he says that I have nothing to do out there, then they may drop it. They may give us
Logically, my lord, that has to be closed.
Huh?
Logically, ICC has to close once he says that will not.
Yes, the ICC will close it and then submit a report out there and matter would be over. So why should this court do it? Because it has this particular proceedings has a tenacity of, if we pass any law to that effect, that if both the parties
followed,
agree,
my lord.
then it will have in
Uh-huh.
all other matters.
Correct.
There might be obviously the bargaining power might be different. You
Well, I have followed,
may
my
be of an equivalent or just much higher. Take the example of a case of a managing director and a small
And they're grade 4 employee.
for stenographer. It may have a huge impact. So therefore, these aspects, I don't think, anyway, let's see on next day. Mr. K. Chaudhary, the learned counsel appearing on behalf of the senior counsel who appears on behalf of the petitioner, seeks for an accommodation. List this matter on 20.
Lordship, can it be
30,
Tuesday, my lord, 28?
28.
28.
28.
I am too.
Or maybe on 4th, my lord.
4th, yes.
On 4th of
Yes,
August
yes.
2026, 2 p.m. for final dispute.
Obliged.
Well, in any case, there is an interim order till next date, my lord.
Interim order passed earlier shall continue.
Reply. এখন আমার file টা কোথায়?
Lordship, in this matter, Lordship, lately state preferred an interlocutory application, Lordship, for implement of the Commissioner and Secretary of the State, Lordship, to represent the state. But that, in response to that application, Lordship, other side have already filed their objection, Lordship. We are going to file one rejoinder, Lordship. It will be filed during the course of the day, Lordship.
What is this? Is it an application filed by whom?
Filed by the state, Lordship. This is 1014, Lordship, 2020.
You want whom to be made a party?
Commissioner and Secretary, Government of Assam in the Forest Department, Lordship.
Why?
Lordship, earlier it was the PCCF, Lordship. And it is the specific objection of the other side, Lordship. He cannot represent the
Want
state.
him to represent the petitioner number 1.
Yes. I mean, now we want the commissioner and secretary to represent the state, Lordship.
Well, why
We
do you have
never
a-
had any objection.
Okay, we allow this application. This is an application filed by the petitioner. Whereby instead of the principal chief conservator of forest and head of forest force Assam representing the state of Assam, the petitioner be represented by number 1, be represented by the Commissioner and Secretary to the Government of Assam Environment, Forest and Climate Change Department, Government of Assam. This court also takes note of that the principal chief conservator of forest and head of forest Assam is already arrayed as a party to the instant proceedings, inasmuch as it is the petitioner number 2. Further to that, considering that the state of Assam ought to have been represented by the Commissioner and Secretary to the Government of Assam, the present application, the opinion of this court is required to be allowed. Accordingly, this court observes that the petitioner number 1, that is the state of Assam, shall be represented by the Commissioner and Secretary to the Government of Assam, Environment, Forest and the Climate Change Department of the Government of Assam. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days. And the registry shall, on the basis thereof, make necessary changes in the cause title and update the same in the CIS. Okay, now come to the main petition. Argue.
As your lordship has allowed the IA lordship, now I think I have to file an affidavit, lordship, supporting the averments made in the petition by the newly
Not
implemented.
necessary. Argue the matter. What is your case?
I mean, that was the objection on the last date, lordship. That
Not
is one of the
necessary.
objection.
They are not objecting. Argue the matter. What is this? It's a long matter. Full matter.
Lordship, this petition has been preferred. I mean, alleging the illegal detention of an elephant, namely Lordship Jaimala, by the temple authority in the state of Tamil Nadu, Lordship. Now, Lordship, there is no dispute as such as regard the ownership of the elephant, Lordship. And there is no dispute as regard permission granted by the state of Assam for transporting the elephant to the state of Tamil Nadu, Lordship. Thereafter, Lordship, it was transported to the state of Tamil Nadu. And after expiry of the period of stay of the elephant, Lordship, that is 3 years, a request was made, Lordship, to return the elephant, Lordship,
By the state of Assam.
by the state of Assam.
Request.
I mean,
First, let's see the permission.
yes. If Lordship comes to page 23,
Yeah, page 24.
page 23 is the Lordship ownership certificate issued under section 42 of the Wildlife Protection Act, Lordship. It was in the name of one Girin Moran, Lordship.
The
Lordship, may
principal
kindly come.
chief conservator of forest writes to the Chennai counterpart.
Next page 24, Lordship.
Page 24 is that
The permission, no objection certificate for allowing entry of domestic elephant to Tamil Nadu.
the Chennai counterpart grants the no objection.
Yes, Lordship, and kindly see the period there, last column, Lordship. Proposal during for duration for staying in Tamil Nadu, 3 years. So it was issued in the year 2011.
No objection is hereby accorded as per the guidelines of the government to transport the Iman so and so, certificate Iman microscript number so and so. Then where are you getting the 3 years?
Page 24, Lordship.
Now, this is for the proposal which was invited.
Yes.
Now, you sought for a proposal, sought for the no objection. The PCCF Assam sought for a no objection from the PCCF Chennai.
Yes.
Now, the Chennai counterpart grants a no objection without fixing a time period.
In page 25, Lordship.
Okay. Now, what happened thereafter?
Next page, one sir. Then Lordship may come to page 31. এখানে type copy আছে নাই? If Lordship comes to the last two lines. Tamil Nadu by truck for its engagement in religious procession and ceremonies up to 1709-2013.
Mention the matter be by so
The
and so
matter by
order.
PCCF WL Assam by his office letter under reference. So time period is up to 17/9/2013.
Okay. Then
Next page is that, I mean, passport, transit
but
pass.
this was
Lordship.
given in 2011
Not.
itself, when the permission was sought for.
Yes.
Then when did you ask back?
Page 54. Lordship, kindly see the subject, request for return to Assam, Jaimala and Lakshmi captive elephant held in Nature Temple of Sri Villapathar in Tamil Nadu and to provide rehabilitation to the elephant. It was issued on 2021, 8/3/2021.
What is their reply?
Next page, Lordship.
This is the same,
Yes.
other communication.
Then if Lordship comes to page 56. It was 12/11/2021.
11%59.
With reference to the above, I wish to inform you, following 9 captive elephants, including Jaimala, have been transported from Assam state to Tamil Nadu and being maintained by temple and private persons. The details are as follows. So these are the details of the elephants, Lordship. Page 59, Lordship, comes to the last two paragraph, Lordship. In this connection, you are requested by reference first cited to inform the details of ownership certificate and transit permit issued for the above elephant, and the details are yet to be received. However, the validity of the ownership certificate and the above elephants were expired and the captive elephants being kept in the temple and private persons beyond the transit period. Hence, I hereby issuing no objection for transporting back the captive elephants to the state of Assam. Page 59, last line. If Lordship comes to page 60, I also request you to facilitate the return of the above captive elephants, including Jaimala, and to take action against the owners of the captive elephants for not taking back the elephants.
Then
Page 62. Page 65. Page 65 is the by Tamil Nadu government lordship. By this letter, lordship, they have informed that if the Tamil Nadu Forest Department has to accept your request of seizure and taking custody of the captive elephants, the cost of maintenance and of captive elephants from the time of seizure till the handover of the captive elephants has to be borne by the Assam State Forest Department and to be paid before commencement of the seizure. I request early action in this behalf. Lordship, may kindly come to page 66. By the state government lordship to the Tamil Nadu, with reference to the subject and letter cited above, it is requested to kindly arrange to seize and take custody of 9 captive elephants at an early date. The cost of maintenance of the captive elephants till they are handed over to the Assam Forest Department shall be borne by the office by this office as proposed by you. An amount of rupees 5 lakhs only is being paid in advance for 20 days and the cost as per the actual estimate to be prepared by you exceeding the said amount shall also be borne by this office. Therefore, it is requested to kindly send official account with bank details for transferring the above mentioned amount in advance at an early date. They stopped cooperating, lordship, thereafter, lordship. In this regard, another mail was forwarded at page 68, lordship. Code allowed. Right. Have to have an additional available. Come back on affiliate.
What is your stand? Why you have not
There-
announced?
there
Who is
after-
appearing for the state of Tamil Nadu?
Sure. My lord, regardless of the delay of 8 years in state of Assam making a request for the transfer of elephant, at a bureaucratic level, initially, my lord, there was a cooperation. But then, my lord, this led to a widespread resentment in the state of Tamil Nadu because these 9 elephants are with the temples. So there was an apprehension that if the Joymala goes, the other elephants will follow. So therefore, my lord, the temple authorities.
It's not the question of
Lord,
Joymala.
I'll
it
come
has,
to that, Lord.
9 elephants.
Right now, we are dealing with Joymala, but
Oh. There were 9 elephants, which was the question.
Yes.
you are asking for
Joymala
authority.
and
But
other 8
Jaimala,
elephants.
Jaimala is given the special interest because of the fact that at that point of time, Lordship, there were several media, reportings now so far as the torture of this particular elephant is concerned. And that is why Jaimala is of
No, that
special-
happened long time ago,
Otherwise-
and now they have already taken corrective measures. Those people have been already
All
removed.
those things have happened, my lord.
Now
Periodically,
things are there. But why?
I'll come to this. So, my lord, regardless of the delay of 8 years, be that as it may, so there was some cooperation at a bureaucratic level initially. When there was a widespread resentment in the state, and because the temples have huge followers. So, my lord, by the temples, there was a writ petition before the Madras High Court that these elephants should not be sent to Assam. And it was at this stage that the political leadership in the state came into action, and it was decided that the elephants shall not be sent to Assam, and the legal rights of the Assam, if need be, would be contested. So, my lord, this is what it is. So, therefore, my lord, on merit, the state of Tamil Nadu has decided to fight out these issues. Whether the state of Assam has got legal or fundamental rights over these elephants, primarily the Joymala, and whether these rights are enforceable qua the state of Tamil Nadu. That precisely is the issue. And my lord, I'll be dealing with all the connected matters. So the state of, before the Madras High Court, my lord, the state gave an undertaking. The additional advocate general had appeared, and by the state an undertaking was given. The undertaking was recorded by the Madras High Court, and my lord, the PIL was closed with that very particular order. So the matter rested there, and then the decision was taken that we will contest this case on merit. So this is what it is.
Lordship, may kindly peruse the judgment, Lordship. That the order passed by the Madras High Court.
I appear for respondent number 8, my lord. It's an NGO, my lord, who basically, my lord, brought the matter to the notice of everybody. Now the question is, my lord, Assam government and Tamil Nadu government is fighting out the issue at the cost of the health of the, my lord, living being. And my humble submission is, my lord, the Honorable Supreme Court has constituted a high power committee, my lord. And as per recommendation of the high power committee, the elephant is now to be kept in a, my lord, rehabilitation center, which is situated in Karnataka. Having regard, yes, it is there.
In respect to this elephant?
Not there generally, my lord, the rehabilitation center is there. In Assam, there is no rehabilitation center. Now, my lord, as far as state of Tamil Nadu is concerned, I do not know what is the nature of the right they are trying to hesitate. It's a repetition of the state where, my lord, they are trying to resist it. Now, the issue is, my lord, first and foremost, the welfare of the elephant is the utmost importance, my lord. Now, Tamil Nadu government the reports are coming, but the real picture is something else. We have got, my lord, video clippings if necessary. We can show, my lord, how the elephant is being maltreated, my lord. So therefore, our concern is the elephant should be sent to the rehabilitation center, which is in the nearest state of Karnataka. And Supreme Court judgment is also there, my lord, and let me place that. Supreme Court 8, na? Huh?
My lord, may I clarify one thing before my learned friend further submits?
I think there is a order is already furnished to your lordships, my lord. Prerna Singh Bindra versus Union of India, my lord. It's an order. Initially, my lord, Tripura High Court, my lord, passed an order which was given in pan-India application, my lord.
And, this one, Murli MS.
No.
Yes, MS Murli,
Murli is coming to us.
MS
Same.
Murli, Prerna Singh Bindra, these are the two orders. And there is it is all on the basis of Sudipta Nath case.
If your lordship would kindly come to that order, my lord, Prerna Singh Bindra, paragraph, my lord, 2. Later in it, has your lordship got it? No? Page 2, page 8, sorry, paragraph 2. Later in a judgment dated 3rd of March 23, reported as Murali MS versus State of Karnataka, a two-judge bench of this court expanded the remit of the committee constituted by the High Court of Tripura to confer a pan-India status. Now please come to para 5, my lord. Mr. Gopal Shankar Narayan Senior Counsel submitted that remit of the HPC should also cover the following aspect. Amongst others, I may have your lordship's kind attention to 3, my lord. Monitoring of health and age of the elephant. Then, my lord, please come to para 7. A remit of HPC would comprehensively cover all aspects, including those which are sought to be raised on behalf of the applicants, as noted above. In other words, all
Let us-
relevant
let us
aspects
see-
are.
No, Mr. Chaudhary,
Yes.
for understanding that judgment, we
Yes.
need to see Murli's judgment.
Yes,
Which is that
Murli, yes.
2023 SCC online. That happened here.
Murli, yes, my lord. Paragraph 9. In view of the aforesaid facts and circumstances, we deem it appropriate to extend the jurisdiction and scope of High Power Committee as constituted by the High Court of Tripura, with the modification that Chief Wildlife Warden of the state to which issues relate will be co-opted as the member of the said committee in place of the Chief Wildlife Warden of Tripura and
Paragraph
Gujarat.
8 is relevant.
Yes.
You see, paragraph 7 onwards.
Though the
attention
scope
has-
and jurisdiction of the High Court Committee was limited.
Paragraph 7, our
Yes.
attention has been invited to a reason and detailed judgment
Passed by the Tripura High Court in so and so, seeking a direction restraining transfer and transportation of captive breed elephant from northeast of India and in particular from states of Tripura and Arunachal Pradesh to the elephant camp of respondent number 3. The High Court of Tripura, while declining to grant relief prayed for by the petitioner therein, constituted a high power committee headed by retired judge of this court, namely Justice Mr. Deepak Verma as the chairman, and members by designation, which included Director General of Forest, Head of the Forest Elephant Division, Member Secretary so and so, for elephant from the state of Tripura and Chief Wildlife Warden. The said order further provides that Chairman of HPC shall co-opt an expert having experience of elephant as a member of the committee, and Chairman may also consider taking assistance of the Chairman, Animal Welfare Board of India. Various well thought out directions were issued for the smooth functioning, power jurisdiction and assistance to be provided to the HPC. Though the scope and jurisdiction of the High Power Committee was limited by the High Court to transfer of the elephants from northeastern part of country to the elephant camp of respondent number 3, we see no reason not to extend it to pan-India, particularly when by extending the jurisdiction of the High Power Committee at pan-India level will not only serve the real public interest and would advance the cause of welfare, care and rehabilitation of the wild animal, but will also curb the filing of frivolous PL before the different High Court by BGBs. In view of the aforesaid facts and circumstances, we deem it appropriate to extend jurisdiction and scope of the High Power Committee as constituted by the High Court of Tripura with modification. From that, this jurisdiction was conferred pan-India. Now, my lord, admitted position is this elephant was taken for 3 years. That period of 3 years expired long back. There was communication between both the governments. In fact, NOC was issued by the Tamil Nadu, my lord. Thereafter, now.
No, kindly read paragraph 9. This
Yes,
is relevant. In view of the aforesaid facts and circumstances, we deem it appropriate to extend the jurisdiction and scope of the High Power Committee as constituted by the High Court of India.
with the modification
the
that
chief-
Chief Wildlife Warden of the states to which the issue related will be co-opted as member of the said committee in place of Chief Wildlife Warden of Tripura and Gujarat throughout the territory of India, leaving it open to the committee to conduct necessary checks and to undertake a fact-finding exercise in any pending or future complaint in this regard. Said committee may also consider requests for approval, dispute and grievance concerning transfer or import into India or procurement welfare of wild animals by any rescue or rehabilitation center or zoo by taking assistance and cooperation wherever needed from all departmental authorities across India. We also directed all complaint in this regard may be forwarded forthwith to the High Court Committee for consideration and recommendation. So, my lord, let a direction be issued from this honorable court to the High Court Committee to look into, my lord, how things are, my lord, what things are going on. If necessary, they will bring the elephant to the, my lord, rehabilitation center at Bangalore, in Karnataka. My lord, naturally, my lord, when
In fact,
political.
in view of this paragraph 9,
Yes, my lord.
more particularly, we also direct that all complaints in this
Yes.
regard
Exactly,
will be forwarded forthwith to the High Power Committee.
exactly, yes, my lord.
So therefore, in view of that,
Yes.
if the state of Assam wants those elephants, why can't the High Power Committee look into it?
Exactly, my lord. That's been my prayer all throughout, my lord. As many.
State of Tamil Nadu may make those.
My lord, that's why I wanted to clarify. My lord, this
One second,
suggestion.
one second, before my learned friend starts, my lord. Kindly see, my lord, political expediency has taken over the stand of the state of Tamil Nadu. my lord. Therefore, no, just now you say the political executives have taken a call.
That's why I wanted to
Just hearing
clarify,
from you.
sir.
Therefore, my humble submission is, my lord, all that I am saying is let the matter be referred to the High Power Committee. Let High Power Committee take a call. End of the matter, my lord.
Yes. My lord, political expediency has not taken over. This suggestion was made by my London friend long time ago. I immediately informed the state of Tamil Nadu. The state of Tamil Nadu agreed to refer the entire matter to the High Power Committee. To that effect, my lord, the order was also issued. It is part of the record. We placed it before the Honorable Court because the Honorable Court wanted me to take instruction on this very aspect. The state of Tamil Nadu duly agreed. They said the Chief Wildlife Warden of the state of Tamil Nadu will be there. The Chief Wildlife Warden of the Assam would be there. They would be the member of the committee. Let committee look into everything, and whatever committee decide, we will accept. But unfortunately, my lord, the state of Assam hasn't agreed. Even today, right now, I am agreeable. Order is before your lordship. I'll again give a copy.
It's okay. Assam, what do you say in view of this direction? This
Lordship.
is a question which
So,
needs to be
my-
educated by the tribe, by the High Power Committee in view of this direction at paragraph number 9.
So that may be one of the way out, Lordship, but my submission will be, Lordship. Lordship, best possible rehabilitation of the, elephant concern will be to allow to rehabilitate in its natural habitat, Lordship. That is a sum.
No,
And
no,
if-
no, Mr. Naik. I'm not on that. If you want that the best possible thing for this elephant should be in Assam, you place it before the High Power Committee for that decision to that effect, and one of your I think the PCCF will be a member out there. Will be a member of the committee in view of this judgment.
Wildlife order.
In
Chief Wildlife
in
Warden.
that situation,
He will be the PCCF.
Lordship, in.
The PCCF will be a part of
in-
it. He will be a part of that the committee.
That
They will have their own PCCF, who will be their part of the committee. That will be deliberated by the committee, and and more particularly, the committee has been given not only will include those persons. Your main anxiety is that the elephant has overstayed out there, But one also needs to find out that you woke up after 8 years or 9 years.
Yes.
Whatever may be, you may have a right. The Tamil Nadu government also may have as to whether the elephants should be out there in the temples or not. They will agitate before the High Power Committee, and the High Power Committee will look into this, including the health and everything can be looked into. So these are things which, in view of this paragraph number 9, it should be referred to the High Power Committee, where the High Power Committee will look into as regards not this elephant one or that all the 9 elephants.
In that situation, Lordship, will allow me some time, Lordship, at least have me some instruction from the state authority, Lordship.
This is the only way. of-
Yes, yes.
My lord, I have given another copy, so it is part of the record. Another copy I have given.
It's okay.
By the government of
the
Tamil Nadu.
state of Assam does not agree. The state of Assam cannot say anything to the debate. Has to be
Let me have that
view
instruction,
of the
Lordship.
judgment of the Supreme Court now holding the field on this.
Yes.
Who is an expert body? Let the HIPAA committee look into
That's
it.
it.
Now, today, anything happens just for example, in respect to forest. It is, you have a HIPAA committee of the center,
That's correct.
appointed by the government, by the Supreme Court, who looks into.
And my lord,
This
HPC
is
is
how
functional.
this said that, when there is an expert body looking into it, why should this court look into?
Yes,
it?
Lordship, at this stage, I am also not opposing, but let me have that instruction, Lordship.
Well,
I'm
is
not
it-
praying for much time,
Lord,
Lordship, 1 week time, Lordship.
Recently, my lord, some of the elephants were sent to Vantara by high powered committee for rehabilitation.
Into.
Yes.
And thereupon those reports, if their report goes against that, I think they directly move the Supreme Court.
Oh, yes, naturally, correct, correct.
Because there, here you have a fight between yours with with the state.
No, in fact,
No,
Lordship, that
Mr.
is,
Counsel, the state of Assam is having a fight with the state of Tamil Nadu.
no, Lordship, this is not that kind of dispute, Lordship.
Why?
Lordship, I will satisfy, I would have satisfied your Lordship, Lordship. I would
No,
have
why
raised
is
those
not a
judgments, Lordship.
dispute coming under 131?
Because Lordship, there are certain judgments passed by the Supreme Court. What are the dispute which can be raised by filing a writ petition also has been settled by the Supreme Court.
My lord, we have raised this.
This is one of those kind of decisions.
131C is the preliminary objection raised by us also in our
Has to
affidavit.
be. Because obviously this cannot be
raised-
decided out there.
That's the reason, in fact.
But today,
No,
Lordship, I am praying for that liberty.
Only one case is there in our High Court, which is filed by the division bench as well as the single bench, where a lottery regulation has been set aside by the state, by Gauhati High Court, where
That was
state of
Maharashtra
Arunachal
case.
Pradesh and state of Nagaland
Ah.
filed and challenged the lottery regulation in Maharashtra,
Ah.
where the state of Maharashtra was made a party.
Justice P.G. Agrawal, I believe, my lord, that is the judgment.
Mr. Chaudhary knows about it.
He knows.
Vacation bench.
Huh?
Initially stayed in a vacation bench.
My lord, only one request, my lord, next week, my lord, I have some part-heard matters in Itanagar bench. So,
Okay, 1 week for, 1 week for the government means 2 weeks for the government.
No, I will file, Lordship. I will have that instruction within 1 week.
my lord, if this,
Lordship may fix the matter.
This
on
Friday.
the date on his.
this Friday,
No, Friday not possible.
my lord, I understand, possibly, it
Of
all
course.
depends upon the honorable CM of Assam.
You
Whether
appear, you appear for
Will
video.
come or not.
Nowadays we are open, we have got a good video conferencing line also. No problem.
My lord, this matter is being dealt with at a very high level in the state of Assam. So possibly that is why they are worried.
It's okay, no problem with that.
So,
No, you are, you see, your presence I will duly recognize when you are there in the TV also.
very
Don't
well.
worry.
So,
Like, heard Mr.
so
P.
Friday,
Nayak,
it's Friday or?
heard Mr. P. Nayak, the learned additional advocate. Ma'am, Mr. P.K. Tiwari, the learned senior counsel, assisted by so and so appears on behalf of the respondent number
226.
2 to 6. You are paying for respondent number 8, Mr. Chaudhary.
8.
Mr. K.N. Chaudhary, the learned senior counsel, assisted by Mr. So and so, appears on behalf of the respondent number 8. The dispute in the instant proceedings is primarily a dispute between the state of Assam and the state of Assam and the state of Tamil Nadu. Inasmuch as it is the case of the state of Assam that though the period for which the permission was granted for the elephant, namely Joymala, had expired and steps were taken by the state of Assam to retrieve the elephant back to the state of Assam. The state of Tamil Nadu have refused to adhere to such request, for which the present petition has been filed. This court duly takes note of that a period for which the permission was so granted was for a period of 3 years, as could be seen from one of the orders so passed by the petitioner number 2 for the purpose of transportation of the elephant. However, it is also taken note of that the state of Assam agitated its rights sometime in the year 2021 on the basis of certain complaints being received to the effect that the elephant in question, namely Joymala, as well as other 8 elephants, have been brutally tortured, for which various requests were made to the principal chief conservator of forest and forest, Tamil Nadu, Chennai, for return of the said elephants. This court also takes note of that initially the officials of the state of Tamil Nadu were in agreement for return of the 9 elephants, which included the elephant, namely Joymala. But subsequent thereto, in view of the stand so taken by the state of Tamil Nadu in a writ petition being WPC number 25120/2022 before the learned Madras High Court, the state of Tamil Nadu has changed its stand to question the legal rights of the state of Assam in respect to the elephants in question. This court also heard Mr. Kane Chaudhary, the learned senior counsel, appearing on behalf of the respondent number 8, who submits that an high-powering expert committee was initially constituted by the learned Tripura High Court in a judgment dated by way of a judgment dated 7/11/2022, passed in PIL number 17/2022. This high power committee was to look into the aspect pertaining to transportation of elephants from the northeast to the state of Gujarat. However, upon certain applications being filed in the proceedings before the Supreme Court, in the case of Muruli MS versus State of Karnataka and others, reported in 2023 SCC Online SC 224, the power of the high power committee, which was only limited to the state of, limited to the elephants being transported from the northeast to the state of Gujarat, was extended to Pan India. In that regard, he, referring to the state judgment, submitted that at present, in view of the state judgment, there is a high power committee who have been empowered to consider the request for approval, dispute, or grievance concerning transfer or import into India or procurement or welfare of wild elements by any rescue or rehabilitation center or zoo, by taking assistance and cooperation whenever needed from all departments and authorities across India. The learned senior counsel therefore submitted that a dispute in the present with petition is required to be referred to the high power committee, as the said high power committee would be in a position to adjudicate these disputes. This court have duly perused the judgment of the Supreme Court in the case of Murli MS Supra and finds it relevant to take note of paragraph number 7, 8, and 9 of the said judgment, which is reproduced here in under. This court also takes note of that subsequent thereto, on the basis of certain reports being submitted, subsequent thereto, the Supreme Court in the order dated 12/5/2023 extended the scope of the
It was in MS Murli itself, my lord, scope was extended.
the scope to deal with various aspects, including the duration of the ownership certificates in relation to elephants, monitoring of the health and age of the elephants, monitoring the facilities for transportation, and the need to shift the elephants. Taking into account, this court also takes note of the submission of Mr. P. K. Tiwari, the learned senior counsel, who appears on behalf of the respondent number 2 to 6, who submits that the respondent numbers 2 to 6 have no objection in placing the matter before the high power committee. Taking into account the above, this court inquired with Mr. P. Naik, the learned senior counsel, a learned additional advocate general, as to whether, in view of the direction so passed by the Supreme Court in the case of Murli MS Supra, as well as the subsequent order being passed on 12/5/2023, can the state of Assam oppose the a reference being made to the high power committee to deal with the disputes raised in the instant proceedings? The learned additional advocate general Assam submits that he would obtain instructions. This matter again on, we have it on 28.
Yes.
Lordship, be it on 6th, Lordship, 6th of August, Lordship.
Huh?
6th of August, Lordship.
Why 6? 4th of August. On 4th of August.
My lord, that very letter from the government of Tamil Nadu may be kept on record. Otherwise, there is already one letter, in fact, with the record.
And in that, have no objection to referring the matter. In that regard, he has placed before this court an abstract of an order dated 29 27/9/2024, which is kept on record and marked with the letter X.
That a copy be furnished to us also, Lordship. I don't know what is the content.
It was given earlier. Anyway, there are, I'll get one. It is already one, even then, because it's a huge bundle, so, but I'll try to get one more.
I'll give a photocopy.
We agreed for it very early. We agreed very early in 2024. The problem is from their side.
We finished on that. This is the matter on court, at the top of the list, bring it as part of. Yes, what is this?
At the heart of which is actually a humanitarian crisis, unfortunately. This is, I mean, a humanitarian crisis.
Aye.
So what has happened in this matter, Your Honor, is it is coming from the winding up of a company called Hindustan Paper Corporation. And when that company was wound up, prior to that, there were a set of dues, including salaries, PFs.
And the company was wound up.
The company was wound up.
What?
IBC, under the IBC.
Then why didn't you go there?
No, Your Honor. So that is not my remedy. What I'm saying
What is
here,
your remedy?
that is why
What is your remedy?
I would want to push back on that a little bit, Your Honor, may give me an opportunity. Because when there is a humanitarian crisis of this nature, otherwise I understand.
You say that these are workers' dues.
The workers' dues, not work, yes, PF dues.
Wait, these are workers' dues.
Yes.
Workers' dues are to be taken as for one of the first and the most important things as per the
That
ethics.
It's not been done. Then
If it is not being done, file an appeal before the
Your Honor, I am-
N-class you cannot, because that has already, did you object to the proposal being given by which the land has been, the land and the building and all these things have gone into, this is good, did it go for liquidation or?
Your Honor, give me a minute. I'll explain.
Is it a case of?
Liquidation.
Huh?
It's a case of liquidation.
It went into liquidation.
And it was ultimately purchased by the government of Assam. That's where
That's a different thing.
that's a yes.
Now,
Not on
once
that.
the liquidation has come into existence. Now certain amounts were received.
Yes.
Did you make a claim before the
Yes, yes.
official liquidation?
The EPFO has been making the claim, they've been pursuing. EPFO has been pursuing, but the claim was not funded into the fund itself. The issue is there. If it was funded, then that's the end of story.
Mr. Das, we are not going to touch this aspect.
No,
We're not going to touch.
so Your Honor, may give me my case is this. You give me a minute.
No, the moment we touch here,
Hmm.
it will affect the liquidation.
I think I have a solution which may not, and there is precedence in this matter which supports exactly my peculiar case, not any other case. So I'm in a very, very, very narrow sliver of a case where there's a state that runs a CPSE, a central public CPSE or a PSU. If that state, and I'm drawing from the case of Kapila Hingurani, which is something I'll place on record, and I want to go through that judgment because that covers me. And it clearly lays out the case that when there's a state that runs a company, the company goes into liquidation. In that case, it was salaries. In my case, it's PF dues. When these dues are not paid, when a humanitarian crisis ensues, in my case, there are 134 people dead. And the last person died beginning of this year. There are repeat number of suicides. People have been reduced to destitution. Some children are found begging on the streets. It is bad. And I don't want to go into the laundry list of how bad these things get, but it is a legitimate, bona fide humanitarian crisis that is accepted. Now, when this humanitarian crisis happens, and this happened with Bhalco, when the reorganization of Jharkhand and Bihar took place, that's when a similar situation unfolded. So there was a humanitarian crisis there also. So in that, the Honorable Supreme Court, through a series of 3 orders and judgments, said that in these unique situations, at least that's what it did there, and I map onto that completely. In those unique situations, the workman should not be relegated to the winding up court or the labor court, which was what the argument was there itself. They said this is the corporate veil protects us. The state's liabilities otherwise are limited by its shares. Totally understand that. But in that unique situation, which is what I'm relying on, it said that the corporate veil ought to be pierced. Corporate veil ought to be pierced. There's a vicarious liability that is on the state to make me whole. And additionally, it went on to say that the state has to act as a model employer. It cannot be permitted to breach the mandate of the EPF Act. These are beneficial legislations with no consequence to itself, because it couldn't have done it directly, ought not to do it indirectly. And it also invoked the concept of social justice and the constitutional conscience. So I'm on that point.
On what point?
The point that since I map onto the Kapila Hingorani judgment, I should be given the same protections, because the humanitarian crisis, which is a violation of 21 as per the Kapila Hingorani judgment, and 300A will otherwise continue unabated.
No, why didn't you approach the NCLT on this?
You know, the EPF was already approached. There is no money there. I'll tell you what has happened then, because the facts are a little bit important. Because what has happened is, when the liquidation happens, the EPF, fair to them, first goes and files a claim, which is what they're supposed to do. They are representing me there. They file a claim. The total dues are 145 crores. Of that 145 crores, 58 crores is the principal, and approximately the balance is towards damages and interest under 7.2 and 14. The liquidator admits 58. So that amount is admitted. The balance the liquidator rejects. So then, against this rejection, the EPFO goes in an appeal to the NCLT. NCLT agrees with the liquidator. They go to the NCLAT. The NCLAT, before the NCLAT, the learned liquidator says that we will reconsider. This is in 2024 now. Liquidation starts in 2018. NCLAT says that please reconsider. So they reconsider. After the reconsideration, they say that no, we are upholding the earlier view of ours, that only 58, because they blame the liquidator. They said, they blame the EPFO. They said that the EPFO's calculation of damages and interest was done in 2021, which is 2 years after, 1.5 years after the liquidation date. Thus, we cannot countenance it. So now I'm stuck. I'm falling through the cracks, and it's not my fault. I have worked hard. I have earned the money. The money has been deducted from my salary. The shareholders, which is the state in this case, has enjoyed that money for whatever it is worth. And then after that, I have been out of pocket. Then the R1 does not pay me. The liquidator files his claim late. The EPFO files his claim late. And ultimately now that issue is pending before the NCLT of how much is the actual claim going to be. But there is no money in the liquidation estate. So what the liquidator has now done is, it's written letters on 60/20/25 to Canara Bank and SBI asking them to refund certain amounts. Now Canara Bank and SBI have filed their own applications before the NCLT. So now these two applications are pending. So now till these two applications are decided, then we'll move to the NCLAT, then to the Supreme Court. There is no money coming, and there is no money.
Why should this court interfere?
Your Honor, to protect me under 21.
No, nothing doing. You are being looked into by the EPF. You go there. If you want to be a party out there, why should this court entertain and have another proceedings out here?
I'm not saying,
Because no, Mr. Das, you have to understand one thing. This IBC is a special legislation by itself.
I agree.
Either you may go for a scheme by which that being some person have purchased it, or go for a liquidation. Now it has gone for a liquidation where the state of Assam has purchased it. It's a different aspect.
Yeah, yeah.
The state of Assam purchases it at a particular rate. The state of Assam has nothing to do out there. But I think the state of Assam have mentioned something in some matter I found out. The state of Assam has stated they will give some employment or something to that effect. Something was
yes,
mentioned.
certain
That is
MOMs
still-
were signed. Certain MOMs were signed. They're on record. I
So they say that we are going to give. That is a different aspect to
fully appreciate.
But otherwise, that is the state of Assam doing it on a humanitarian ground,
Yes,
whatever
yes.
maybe. That is a different aspect. But as regards the EPF payment and all, it is for the liquidator to look into it. And the liquidator, if he is wrong, it is the NCLT who has to look into it. Why should this court interfere? This court cannot interfere with this. You want to be a party, go there and become a party out there. Nothing to do here. And EPF is looking into their issues.
So
What
my-
is this?
No, so let me agree with Your Honor once. There one more aspect I'll bring to Your Honor's notice. In agreement with what Your Honor is saying, there is in fact a recent judgment that has come by Jet Airways in the Jet Airways matter, and the view that was taken by the liquidator here is that any due that is unfunded is not part of anything. It evaporates. Whereas the Jet Airways judgment has now come and said that studying certain Supreme Court judgments that were relied on, that actually the dues, the PF dues, these workmen dues, constitute what it calls a super priority.
It is there. There's no
I-
quarrel with that.
No, there was a
Mr. Das, I think you have to understand.
no.
See, when the charge is there on the particular amount, there are various charges. The first charge is on the workers. The workers' charge is taken at the the first. Thereupon comes the statutory, and the last comes the state dues.
So
The
actually,
state.
so
There's a
actually,
quarrel. There is a proposition out there. You will find it out there in the company.
no. 53, Your Honor. Your Honor is referring to the waterfall mechanism set out in section 53A of the IBC.
No, 53A is already there, but then also earlier you follow the Companies Act. There's a
Yes,
particular procedure which
433,
is being-
433, 434 waterfall mechanism was there.
No, not 433. We'll
Oh,
see.
very well.
We'll see at 2 o'clock.
Very well, yeah.
But this type of litigation is not.
Your Honor, I think Kapila Hingurani is where I will. Your Honor, I've handed over a convenience compilation. I'll just read the Kapila Hingurani judgment. This judgment says what I want to say much better than I can. So, Your Honor, may I have page 28? I've actually flagged it. Your Honor, 28. It's the effective at page 30. It starts at page 30. Para 1. If at all, and to what extent the government of the state of Bihar is vicariously liable for payments of arrears of salaries to the employees of the state-owned corporations, public sector undertakings, or statutory bodies is the core question involved in this writ petition.
No, you have not brought those relevant judgments. Your judgments are have nothing to do. You are with the PF dues.
No, Your Honor, no.
These judgments have not.
With utmost respect, Your Honor.
The judgments which are of relevance are the Mozabair judgment. We look into the Mozabair judgment.
See, Your Honor, those get distinguished. The
No.
reason
Your question is that you are to get your PF dues and
Yes.
gratuity and all.
Yes,
That's it.
yes.
Have you looked into Mozabair judgment?
Your Honor,
My question is, have you
yes.
looked into Mozabair judgment?
what I've looked into Mozabair's judgment and I
Now, what does
understand.
Mozabair judgment say?
So the Mozabair's judgment says that the workman dues do get cleared from the through the IBC process.
No. That is why I'm saying that you have not looked into. You have not looked into Mozabair judgment. You have not looked into the Savan Godiawala judgment.
Actually, sir,
You have not looked into those judgments.
those
You see, no, you have to understand. Mozabair judgment categorically says that look here, PF, gratuity, as well as pension funds are dues by the corporate debtor. And as such, it has to be taken out excluded out of
yes,
the liquidation estates.
yes.
Estate. Therefore, first and foremost, you satisfy that, then only 53 can be applied.
Your Honor is preaching to the choir. I totally follow that.
So therefore, your case should have been, look here, here is a case, the official liquidator has distributed the assets in terms with 53 without first exhausting the amount towards gratuity, provident fund, and pension fund. That is your case. First, it has to be taken. This does not even come within the ambit of a pari passu charge under 53. It has to be taken first. Even
Yes.
at the moment.
Yes,
That's
yes.
Mozabair judgment.
Yes.
Then Savan Godawala judgment follows Mozabair. and then NCLT says no, then also as per 53, it has to be given by the NCLT. Then the matter goes to the Supreme Court. Supreme Court says no. Taking into account Mozabe's judgment, first it has to be whether separate fund has been made or not. First, it has to be taken into that aspect, and then yeah, that is your case.
Your Honor, my case is different.
These are the things which
No.
now,
Your Honor,
now the bus have already traveled. Now, after liquidation, everything is being over, then you have come before this court.
That is not correct, Your Honor. That is not my case. I totally follow what Your Honor is saying. And in fact, the Jet Airways case that I was relying on, in fact, follows this thread itself. So
No, you are relying upon a judgment when IBC had not come into being.
No, the Jet Airways case is now to 2026 June.
Jet Airways also follows Mozabe.
Yes, I agree, Your Honor. I'm not disagreeing.
Jet Airways
I have-
also follows the same
I have no
principle.
quarrel with that. I have no
But
quarrel.
you're referring to a judgment of 2003.
No,
It has no relevance out here.
Your Honor, with utmost
Because
respect, it does have
2003
relevance.
Judgment comes on the basis of the Companies Act 1956, not even under the 2013 Companies Act.
But the principles apply, Your Honor, in this matter. Your Honor, may please let me read Kapila Hingurani
Not
judgment.
interested. But first of all, you tell me, why should this court entertain when there is a proceeding going on before the office?
Because of Article
see.
21. That is what the judgment says. That's why I'm
No,
relying on the
Article
judgment.
21 aspect would be very well looked into by the NCLT to that effect. And if there is any violation to that, you are already fighting out there.
Yes, Lord.
You are already fighting out there.
Now.
And if it is not being given, you have to then
No.
go to NCLT and the Supreme Court will grant you. This is not the forum by which you are moving this court. Your thing is already been looked into by the EFFO.
My grievance
Yes.
not that they are not looking into it, Your Honor.
Then
by the-
why should we have a separate
because-
education?
Because, Your Honor, by the time the money comes, by the time the.
No, by the time the money comes is not the question.
It is, Your
Here
Honor.
is
This
a
is what the
case
judgment
where the
says.
official liquidator is already been taken into action by the NCLT. Official liquidator had made a mistake. There's no quarrel with the fact that the
Yes.
official liquidator has made a mistake. The official liquidator first should have got whatever money they have got, first should have given it to you. There's no quarrel
Yes,
with that
yes.
proposition.
Yes.
That is what your case is. Why you're trying to divert from what your case is?
My
Your
case,
case is, no, listen, your case is, then look here, this is the provident fund amount, this is the pension or the gratuity which I am entitled to. This amount should have been given to me first and foremost, and after that, you then apply the pari passu charges or the priority claims in terms with section 53. As regards your 24 months salary, your 12 months salary, then comes the statutory dues, the government dues, all these things comes later on. First and foremost, you have to satisfy. This is the case.
my case is a little different.
Yeah, what is your case then?
Yes. I follow that. I understand that the process is going on, and I understand that is where in most cases the remedy would lie. I'm not denying that. That is why I'm not arguing that point. My case is that in this situation, there is a humanitarian crisis. It is true. There are people dying. And because people are dying, they're suffering. I'm in touch with the family. There is grief. And there are legitimate issues for non-payment of money. Now I can, if I'm relegated to wait for the
You
outcome.
are not relegated.
No,
No, you are not
no,
relegated to
if I am wait,
No,
if I,
Mr. Counsel, you are not to be relegated anywhere.
yeah,
Your
May- may
question
please strike
is,
that word.
no. First, EFFO, if they get the money out there from you, they will distribute it to
yes,
you.
yes,
You are not
Don't-
relegated.
No, that's not what I mean. I apologize for that word, Your Honor. What I'm saying is if I'm made to wait, my issue is with the delay. And what the Kapila Hingurani judgment deals with the fact that what happens when people are already in a state of distress. I am out of pocket since.
Now, how do I give you the money? Tell me.
Yes.
Give me a
So, solution that I had in my mind.
yes. Tell
My
me.
solution is that I do not want to disturb that process. Let that process continue. Let the liquidator do what they're doing. Let the EPFO do what they're doing. The liability as per these judgments rests with the sole shareholder, which is respondent number 1. There's no dispute in that as per these judgments. The liability lies there. So let the respondent number 1 make me whole through the EPFO. And whenever the process completes, whatever money comes, let him step into my shoes and collect that money. I need it today. My issue is with the timing. My issue is not with the process itself. Process is so let the liquidator continue what he's doing. Let the EPFO continue what they're doing. It's going to take some time. There's no denying that. There's no denying that they are the NCLT now. Supreme Court will happen. The challenges from the shareholders, the secure creditors are pending. So it is not something that is getting over in a few days. But people are suffering on a day-to-day basis. So my solution is that let the respondent number one make me whole. It is their due. It is the liability falls to them. They are the
Why?
ones, because as they are the sole shareholder, that is what the judgment holds. But piercing the corporate veil and the concept of vicarious liability places it with them.
Was HPC, the government of India was the sole shareholder?
Yes, yes, yes.
Show me that,
Yes.
that it
Your
is a sole shareholder.
The articles of association your honor may have.
Show me.
This is not in dispute. They in fact
No,
have an
let-
affidavit.
let-
Yes.
Let us see.
Annexure A2. Page 58, your honor. I think you put that.
What is it?
There's no dispute with the fact that there was a sole shareholder.
Show me. How is it? Yeah. Don't make that submission.
No, no.
Just don't make a submission for a sake. It's a private limited company. It has shareholders less than 50. It is not even it is a government company in terms with section 617 of the Companies Act 1956. That I know to that effect. But there are other shareholders.
I think there's one other shareholder, your honor, but
There's not one other. There are many more. Don't make that submission.
I'm relying on. I'm relying on this, your honor. 1 second. Your honor may have their affidavit that they filed, which is at page 427. Honor may have that. In the NCA record, just look at that also. Give me the form.
Yes.
427. No, 427. Yes, yes, fine. Your honor, page 427, para 2. This is the respondent's own affidavit in an earlier writ petition that they filed. The 100% Government of India owned central private sector enterprise under the administrative control of the DHL.
These are all salary claims.
No, Your Honor. Provident fund.
Wages. Provident fund claim.
No, yes, Your Honor is at the Kapila Hingurani judgment. Your Honor is at the Kapila Hingurani judgment.
No, yeah.
So these are PF dues.
Is-
The relevant page number for the dues would be page 271. Math page 271. The EPFO own document. Nine 2021.
And 145 crores.
Please, as of 2021.
We were entitled to 58 crores.
As principal.
Huh?
Yes, as principal. The balance is interest and damages.
Mr. Roy, how much amount has been paid till now?
The liquidator has given the details in his affidavit. Sixty. 60.
The answer, Your Honor, is that
Your lordship comes to the affidavit filed by the liquidator, my lord. That is there, my lord, in page 460. Even if lordship comes to the affidavit filed by the liquidator, my lord. Respondent
much?
7. If lordship comes to page 458, my lord, in the affidavit.
60?
458. paragraph F, my lord. Similar issues,
458 is his prayer. I'm not on that.
458 of my affidavit, my lord.
This is what I'm saying. How much amount have you paid? Had remitted to the EFO a sum of rupees 213,
13 crore.
which is so and so more than the funded balance amounting to rupees. The details of the funds remitted by the liquidator is under receipt of rupees 206 crores 67 lakhs so and so. Receipt of rupees so and so. Till 213 crores have been paid.
Lordship, that is remitted to EPFO. But if lordship comes to
And
pay,
have the amount been made, the payment has been made to the EFFO?
Yes, yes, yes. So the funded
that is-
amounts have been received.
Huh?
Funded amounts have been received.
Then
This is the unfunded amount, the 145.
that is pending adjudication before the NCLAT.
Your
That
Honor,
part is pending, my lord. And if lordship comes to page 458, similar issues pending adjudication before the Honorable Delhi High Court. Lordship may kindly peruse page 458, 450.
another similar petition is filed by Kachar so and so versus Union before the Delhi High Court.
Asar paper projects worker union intact versus Union of India.
Paid the unpaid
and
dues, wages and legal.
The
fees to
issue there, my lord, paragraph B,
So that matter is pending.
that is pending before the Honorable Delhi High Court.
no,
And
this-
it was
that's
filed
not
on
us, sir.
2020.
Union filing the two cases.
No, I don't think that is us, Your Honor. This is INTUC, that's not us. That's a different union. We are appearing for two
That is
separate unions.
INTUC,
It's not us.
Indian National Trade Union Congress.
Who is the petitioner?
The
There
Indian
are two sets of writ petitions, Your Honor.
Kasar paper project worker,
One
Wait.
union is opposed to it.
and they are under
Workers
not
and
us.
employees.
Us.
This is the workers union.
Yes. There are two. There is Kachar Paper Projects Workers and
but the
Employees
issue
Union.
is
and
the
Mazdoor Sangh.
PFD only, PFD of the workers.
Same issue.
An employee union. You are appearing for
Liquidator, my lord.
liquidator. How many members you are having?
Your Honor, the list is at page, ends at page 271, if Your Honor may
Huh?
have that. 271.
All these people.
Yes.
And they are not members of the other union.
No, not to my knowledge.
No.
No. These
Because
are
they
the
have
people
put
that
it on affidavit.
Hmm?
There is another writ petition pending.
but that
You are
is not-
saying that they are not members of your union.
These are the people I'm representing here. I'm actually tied to the EPF code NEGHY 12014. And we have 208 members here in total.
National Trade Union Congress.
No, it is affiliation.
Oh,
So there are total 208 and
So
412
your
people.
members have not got a single penny.
No. We have got the funded amounts have come. I'm not, there's a portion that is the funded amount and portion that's the unfunded amount.
What is this funded amount?
Funded is the ones that was deposited in the trust. But the company HPC had deposited certain amounts in the trust, the EPF trust. So those have been dispersed. This writ petition took those monies out on the basis of humanitarian grounds only, because it was invested in different places. So they said, please get it out, distribute it because there's a crisis. So that is now a settled issue. If your honor may have page 271, it'll actually become clear. 271. This is the liquidator's own document where he did an entire audit of the dues that are payable.
You refer to the,
Your honor has
this connection, it is to inform the PF and
271,
payable interest under 7Q along with pendant.
261. I apologize. Your honor. 263. 263. I've already shown 271.
So
263.
here only 58 crores is left.
Yes. As for the
So
unfunded.
what is this humanitarian crisis on your part?
No, so what has happened is that because the amounts have not come in, because we have been out of we were not paid salaries for approximately 4 to 4.5, 5 years, out of which when the settlement takes place, we get only 2 years. So the gap of 3 years is causing a lot of devastation within the family members. So it's not like we've been made whole or that, the money has finally come in. And even for the PF amounts, only the funded portions have come in. So each family has gotten some portion of this 112 crores has come in, which has gone to the respective family members.
112 crores or 213?
No, that is for the entire HPC. I'm only for the Kachar paper mill unions.
No, Kachar Paper Mill Union has already filed. You are Kachar Paper
No.
Mill Employees and Workers Union.
Yes.
There is already another union who has filed, that is the Kachar Paper Mill Union.
No, I'm for the, so the Kachar paper mill had multiple unions. So all the people who.
You are not registered under in TAC.
No. I'm
You
a
are
separate
registered
union.
with under whom?
I'm a society, I think.
What society?
No, the union is not registered with Intact. We are a
You are
part.
registered under whom?
I'll just check that one. You've given the documentation.
Where is your trade union certificate?
The trade union certificate is not on record.
Bring it on record, then we'll consider. Because we have
No, very
serious
well.
doubts on this. Serious.
And I'll also clarify the issue of whether we are part of Intact. If there's any dispute, then the consequences they will follow. Tell me.
And secondly, the sports.
Associate.
Why you are filing this writ petition without bringing on record anything to that effect? Who are you?
No, we filed the letter.
Huh?
Pardon?
And you bring on record the affidavit, the writ petition filed by the other trade union.
Lordship, that is on record, the delay.
Where is
And
it?
I'll bring that. I'll bring the petition.
Please.
Even your lordship comes to page 461 once, my lord.
Page?
Page 461. 461. 461. Approximately 651.83 crores has been disbursed to the employees of a special.
How much?
461 of the affidavit.
Much it has been disbursed?
651.83 crore.
Been disbursed.
Lodge.
The petitioner have not received any money.
They may, I cannot say. But the government
No,
of
you have to look into it, na? You are the official liquidator.
those are
Now
315.
tell me, no, Mr. Counsel, you tell me. You are the official liquidator who is to disburse the amount.
But if
The
EPFO
corpus is with you. Now, one trade union is another day. We have find another trade union who has already filed. Have you released to any members who belong to this trade union?
This chart shows, my lord, that has been remitted to EPFO, that 213 crore. And in paragraph H, my lord, the PF dues that 213 crore, then 79
So
lakhs.
therefore, as per B, so you have
79
already remitted the PF dues.
Lordship. And the
200.
government of Assam has paid 359 crore
In addition to this,
in addition to that. Total 66
government towards the outstanding dues.
towards outstanding dues
48
on humanitarian ground.
That I remember. There is another case where somebody filed a writ petition seeking for contractual dues. I think it was by Mr. Samaria. Then I said that we can't do anything to that effect. The liquidation has taken, you may have to go before the liquidator do whatever may be. There I could see one decision by the government to make certain payment to those outstanding dues by the government of Assam. Anybody paying for the government of Assam? No.
Government of Assam has paid through AIDC.
AIDC.
To AIDC.
This 359 crore.
They're a respondent.
And they have disbursed it.
To all those employees.
You have got this.
Because this is
Then what is the urgency for this court to entertain this petition?
Because
When, no, absolutely no. You have the money.
they do
Don't
not,
come
Your
up
Honor.
with this immediately.
With utmost respect,
Already
Your Honor, this some
651 crore has been disbursed to the employees.
The dispute is to be taken up by you. And Mr. Roy, what is your case? You are now dealing it, we are making claims before the NCLT.
Case came before the liquidator. Liquidator has made certain amount. We, pursuant to the order passed by the NCLT earlier, we raised revised claim
Against that, my lord, they have approached the NCLT. NCLT has passed an order, and against the order of the NCLT, now the matter is now pending before the NCLT. The claim is in dispute, my lord, before the.
They are looking into it.
They are looking into it.
That is also pending.
That is also pending, my lord.
So why should we entertain this
That's
type
right,
of
my lord.
secondary
That's-
petition
that's-
out here?
So there.
My lord, kindly see the order of lead petition number 6330 of 2019, my lord. Assam.
6330, they have an next.
And then,
We have an next data.
They have an next.
and the case number.
Is it enclosed?
Your Honor will find this at
424. Oh, sorry, my lord. That is the application. Sorry.
295, no, 377. The order passed,
77.
377.
No,
একটু আগত।
itu agak tuh. Itu alia 377 now.
294.
Next please.
The 6330 order is at page 292, my lord.
292, no? Yes. Last part to full second. Take a second.
This is by the Kachar Mills
Same.
Officers and Supervisors Association.
Yes, madam.
Kachas Paper Mill Officers and Supervisors Association and another.
And what is the other petition? Ah, this is the other one.
This is the culture.
They have again filed another.
Yes, madam.
Why?
No, there are two connected writ petitions, Your Honor.
No. Why? Who is paying for this Kachar Mills Officers and Supervisors Association?
Please.
Who is appearing?
Is it the item number 6 today? Yes.
Then how are you appearing, taking into account the judgment which have been passed by this court, the coordinate bench on 66330/2019?
The
The challenge to this order, how are you filing the other writ petition?
we had gone in a review, Your Honor. Your Honor, I have page number 297.
Page?
1 second, not 297, which is the other page number.
They filed the
377.
review application.
Which-
That
I'll
was
put the full facts before Your Honor.
review
Your Honor can take a
application. Oh,
377.
Review here, sir.
review
Dismissed,
is
right?
dismissed.
Has this order been reviewed? Then how are you filing this second writ petition? First of all, the matter is pending in the Delhi High Court. Second of all, the matter is pending in NCLT. Matter is pending before the official liquidator. Government and you are coming out here that you have not got a single penny. This is what the impression we have got it in the initial submission. Isn't it your submission earlier? No, Mr. Das, you made the submission that you have not got a single penny.
I never-
People are dying, people are begging out there.
That is true.
No,
Your Honor, my submission is that there is a humanitarian crisis because
no,
the money is
there
there.
cannot be a humanitarian crisis in view of that. Tomorrow, a person may require a certain amounts, just for example, a contractor question. He has spent everything and the government have not made the payment. Now, because of that, if he has not proved that he has done the work, can this court say that, okay, humanitarian crisis, kindly make the payment to him?
That is not what I'm saying. I have worked.
I think I'll dismiss this. Heard Mr. DJ Das, the learned counsel.
D. Das, Your
এখন লিখিব, এখন লিখিব।
TJ Das would be somebody. D. Das.
The learned counsel appearing on behalf of the petitioner. Mr. What type of writ petition is encourages? This A guy on appears.
One
on
small
behalf of
submission,
the
Your Honor.
respondent Number one.
Your Honor, may,
Appears for the state of Assam. So and so appears for.
Your Honor, may
respondent
please
number
permit
two
me
And three. or 4. And you appear for 5 and 6.
5 and 6.
E.K. Roy assisted by so-and-so.
Each.
And Mr. So-and-so appears for the respondent number 7. The petitioners herein. Petitioner number 1 herein aims to be a union, trade union, in the name and style of Kachar Paper Project, Workers and Employees Union. Petitioner number 3 also claims to be another organization, namely Kachar Paper Mill Mazdoor Sangh. And when did the trade union come into existence in 1956?
Heavily subsequent to that, Your Honor. Your Honor, permit me some time to present these data.
No. Trade Union Act came in 1956.
I'm not sure. I'll just
Both the petitioner number 1 and 3 claims that they are trade unions. However, on record, nothing has been placed that the petitioner number 1 and the petitioner number 3 are registered trade unions. And have been duly issued certificates. The petitioners herein further claim that their members who were working, who are their members, were employees in the Kachar paper mill. One of the paper mills belonging to a company in the name and style of Hindustan Paper Corporation Limited. This court further takes note of from the materials and record that the said Hindustan Paper Corporation Limited, for short the HPCL, had gone into liquidation the claims of the members of the petitioner union, the claims of the workers and employees of the Kachar paper mill whose grievances are sought to be espoused by the petitioner number 1 and 3. Is that a humanitarian crisis have arisen on account of non-payment of the Provident Fund as well as the gratuity and other dues. And as such, this court should, in exercise of the power, should, taking into account the provisions, taking into account Article 21 of the Constitution, direct the respondent number 1 to make payment of the dues, the provident fund dues, and provident fund and other dues to the petitioners, pending adjudication by the various authorities under the Insolvency and Bankruptcy Code 2016. This code duly takes note of the affidavit which have been filed by the respondent number 6, respondent number 7. From the said affidavit, it is seen, respondent number 7, who is the official liquidator of the company, namely HPC, which has gone, of the company, that is HPCL, which has gone into liquidation. In the said affidavit, which was filed, on 19th of June 2025, it is categorically mentioned that presently the dues payable, the additional, it has been categorically mentioned that the issue which have been raised in the present writ petition have also been raised in another writ petition which is pending before the Delhi High Court. Another union in the name and style of Kachar paper, in the name and style of Kachar paper projects workers union, that is writ petition number 1062/2020. In addition to that, it has also been mentioned that as on the date on which the writ petition was filed, the affidavit was filed, an amount of rupees 213,18,14,728 have already been disbursed to the Employees Provident Fund Officer organization. In addition to that, there has been already a payment of rupees 79 crores 51 lakhs 60,919 towards wages in terms with section 53 of the Insolvency and Bankruptcy Code 2016. It also mentioned that apart from the above, an amount of rupees 359,13,97,613 also been disbursed amongst all the employees by the state of Assam through the AIDC. In other words, as on date, the employees of Hindustan, of the Kacha paper mill of Hindustan, this is for all or only?
This is for all, HPCL all.
For the, in other words, the employees of the HPCL, which has gone into liquidation, have been already disbursed an amount of rupees 651,83,73,250.
260.
This aspect is not disputed by the petitioners. This court also takes note of pursuant to orders being passed by the NCLT Delhi and further appellate orders passed by the NCLAT, learned Swans. The NCLAT, the learned NCLAT Delhi, is presently in session with the further additional demands made by the EPFO. This court further takes note of that the IBC 2016 is a self-contained code. Already it provides for various procedures. And the issue which is being raised by the petitioners herein is presently under adjudication before the authorities under the IBC. The learning counsel appearing on behalf of the petitioners, on the other hand, had submitted account of humanitarian crisis. The amount which the EPFO has claimed should be disbursed by the respondent number 1 and subsequently upon realization of the said amount, the respondent number 1 be reimbursed the said amount by the EPFO. This court would have considered the said prayer had it been a case where not a single penny would have been paid. However, not the case, as would be apparent from the observations made here in above, what have been noted here in above. Court also finds it very relevant to observe that in the circumstance this court passes such directions as have been sought for by the petitioner, it would not only interfere with the proceedings which are pending before the NCLAT, but would also be contrary to the provisions of the Insolvency and IBC 2016. Accordingly, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Before parting with the record, this court makes it very clear. Dismissal of the instant writ petition is on the ground of being not entertained for the reasons aforementioned. and the same shall not in any manner affect the rights of the petitioner to their dues, which is presently pending before the learned NCLAT, New Delhi.
Similar order in the second
The
application.
other one I impose with the cost of filing this. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of respondent number 1. Appears for the respondent number 2, 3, 4, 2 and 3. Mr. Ekakoti appears for respondent number 4. Mr. So-and-so appears for respondent number 5 and 6. And so-and-so appears for respondent number 7. Present petition has been filed. Seeking a direction upon the respondent number 1 to deposit the pending PF dues under EPF and MP Act 1952. By the respondent number 1, direction upon the respondent number 1. So it is relevant to take note of. Where is the judgment here? Here, have you enclosed the judgment? Have you enclosed the judgment here?
Yes, yes.
He to file
Same
this.
set of documents have been filed.
Huh?
It would be enclosed.
You have not?
No, it would be enclosed. Same set of documents have been filed. Let me just. I think the order, your honors. The last.
Take the welfare resolution. It is 6448. XMSL. Your lordship will find it as page 260.
96. 196? No.
6468, another writ petition that was filed. 6468 2019, page 268.
271 being the operator code.
Yeah. We have it, this order, 2868. This court finds it relevant to take note of. The present union, petitioner union, has already filed another writ petition before this court. Claiming the same relief, which was registered and numbered as WPC number 6330/2019. The learned court in a bench of this court by an order dated 9/2/2024. In view of the pendency of the pendency before, in view of the proceedings being pending before the liquidator, was not inclined to interfere with, was not inclined to proceed with the said writ petition. More particularly, as the statutory authorities under the PF Act were looking into the matter of non-payment of the statutory provident fund. The relevant portion of the said order dated 9/2/2024 is reproduced here in under page 272. Accordingly, writ petition is then disposed. Mr. D. Das, the learned counsel appearing on behalf of the petitioner, submitted that in pursuance to the said order, the petitioners the members of the petitioners union though have received certain amounts, amounts have not been paid, and therefore the present writ petition has been filed. This court duly takes note of the affidavit filed by the respondent number 5 and 6, wherein it is mentioned that the EPFO had filed claims before the liquidator appointed by the learned NCLT New Delhi bench by the order dated 14/5/2019. It is also mentioned that the total claim amount is rupees 386.48 crores for in respect of the entire HPCL which included the Kachar paper mill as well as 2 other units. This court also takes note of the affidavit which has been filed by the respondent number 7, na? Respondent number 7, wherein it is mentioned that an amount of rupees 213,18,14,728 have already been paid to the EPFO. In addition to that, rupees 79,51,60,919 have also been paid in terms with section 53. The IBC 2016 towards the salary and arrears of salary. Further to that, the state of Assam through the AIDC had already disbursed an amount of rupees 359,13,97,613. In total, an amount of rupees 651,83,73,260 have already been paid various employees. Petitioners have not disputed the said aspect. The grievance of the petitioner is only limited to the further amount so claimed by the EPFO, which have not been disbursed by the official liquidator. It is relevant to take note of that the said aspect is presently under adjudication by the learned NCLT. 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 New Delhi. And as any interference with the said application which is being carried out by the learned NCLT would be contrary to
Oblige, Your Honor.
May I please, Your Lordship?
Yes, what is your stand, Mr. Counsel?
My lord,
What is your stand?
my lord, I have filed affidavit in opposition, my lord.
What does it say?
I have stated everything in my affidavit of opposition, my lord.
Filed by the respondent number?
Five, my lord. That is in page, my lord. 32 start. Start.
You are also not the owner of the land.
No, my,
You are also possessing.
my lord. This is the,
And you say that the petitioner is not possessing.
no, my lord. Not in possession. One Mojid Khan, writ petitioner to father of the writ petitioner to was in possession, but before 8-9 years ago, my lord, he sold the said possession to one Moniruddin. And said Moniruddin got compensation more than 50 lakhs. Record is not my in hand, as the most of the land was acquired from his portion.
So this is a case of 45,000.
No,
Now
5,07,022.
one is 5 lakh something and another is 45,000. There are two land, two.
One is that
Two lakhs.
number 1671.
1671, my lord. Only, my lord, 10 lesas of land, which is now in southern portion of the part number 1671 plot number. Only 10 lesas of land acquired, which has been in my possession from my fathers and also my grandfathers. I have more portions of land in 1671 also, that only 10 listas of land touches.
Now kindly come to paragraph 10. Your affidavit.
My affidavit.
You say that you are not willing to take that amount.
Yes, my lord.
Return them.
Till that I have not withdrawn.
You don't want because it is a coercion.
Corporation, my lord.
Now kindly come to paragraph 13. Was occupied, possessed by the deponent and the writ petitioner number 2. But the northern part of area was occupied by the writ petitioner number 2, which was sold to one Moinuruddin, and the said Moinuruddin get compensation for the said portion
Yes.
of land. The southern part of area has been occupied, possessed by the deponent, so the company awarded compensation to the deponent. The deponent further states that though about 100 families have occupied the land under patta number so and so, but nobody can be able to enter their names as royalty. How the writ petitioner able to enter their names in the draft sheet as royalty is really astonished by the deponent. Moreover, Dag number so and so is occupied by the deponent and one Moinuruddin Ahmed. In the present Dag Javabandi annexure A of the so and takes no name as royalty, so the writ petitioner is duty bound to prove annexure 1 of so and so. Number 1676 is the Koborstan. So Koborstan you have no dispute.
No, no dispute.
As regards the 1671 is the issue. Now, why do you say while receiving the compensation, kindly come to the affidavit filed by the respondent number 1?
That was,
Annexure R1,
that,
running page 62. This is your affidavit.
that is not sharp to me, my lord. What
Huh? Please give the copy of your affidavit.
My lord. Regarding this affidavit, my lord, as this was not sharp to me, my lord.
I, along with so and so, have been possessing the land of so and so covered by Dag number so and so of so and so. So you duly claim that you are, and who is Mojibullah? What is your name?
My name is Ayazuddin and
Ajit Ali,
Mojibullah and Ayazuddin, 1 and 2.
1 and 2.
1 and
So you say in your affidavit that you along with these two persons, that is the petitioners, are in occupation of this 1671.
Yes, my lord.
And number 5, that I do hereby declare by this affidavit that I will divide the share of compensation along with my aforesaid co-patadars. This is your stand which have been given on the basis of which you received the amount.
Yes, my lord.
Now you are trying to say that he is not in possession. The petitioner number 2 had a possession, but he has sold the possession to one Moinuruddin. Okay. But in this affidavit wherein you have submitted, you have categorically admitted that the petitioners are in possession.
Now I would like to say, my lord. Regarding this affidavit, my lord, just today, my lord, before 1 hour, I have also communicated to my client, my lord, Sirajul Haq, how you have signed it. What happened, my lord, regarding this affidavit? One typist was drafted that affidavit, my lord. On that day, when we went to circle office, affidavit required, and they said me that you have to show an affidavit that this is your land. And accordingly, one typist was drafted, hurriedly drafted, and when it was drafted, I asked him to understood me in vernacular language, but he understood that this is your land. Only my person was reading it. And subsequently, my lord, that
You mean to say that you could not understand this meaning of what
and
is
not
there?
only that, my lord, some other pages also, my lord, took in signature, but subsequently they had submitted this one, my lord. This,
Who has submitted?
my lord, one typist, and there subsequently I asked to that typist, and typist said that I did not do so, but they have done so. They have changed that.
Who have that?
My lord, the writ petitioners. That is the, my lord,
Tell me.
oral information.
So tell me, this certificate which you have, affidavit which you have given, prior to that, court which has been given under 3G, the name of all 3 of you are there. Why did you claim that? Did you know that the claim was that all these three persons' names have been mentioned out there in the 3G award, that for tag number 1671, these are the three persons?
No, my lord, notice, kindly see in affidavit, my lord. Page 53, my lord.
No, no, not your affidavit. My question is here, kindly see this. Kindly come to page 68
Of, my lord, this petition.
of that document. That affidavit.
What do you want to? আপনার ফোন
গভৰ্ণমেণ্ট কিমানৰ পৰা আৰম্ভ হৈছে 93 পৰা এইখন কাৰ এইখন নহয় এইখন
Where is 1671? In your affidavit? Of your statement, where is 1671?
my month 97 page
See?
97 10 my lord.
No, no, where is your statement in that document? There has to be an award statement. This is the award statement. This is the 3G, page 68 onwards.
Yes, ma'am. That is a statement, my lord, Annex 3, page 63, in affidavit filed by the respondent number 1, my lord.
Ah, where is it?
That is at page 68.
Where is that 1671?
That's not, sir. My lord, it is not readable, so client, this is, this one, 68, maybe.
Yeah,
my
that
lord.
is 1611. Then you have 1612, 1613, 1614, 1615, 1635. You don't have 1630, yeah? Yeah. This will page 69. Page 69. Wherein it is seen the possession is of two persons. One is Sirajul Haq and one Moinuruddin Ahmed. That is 1671.
Yes.
ধৰিব পৰা নাই।
Where is 1671?
My copy is not clear, my lord, so
Which one? Page?
page 69, my lord.
That appears to be.
Yes.
There are two persons. One is,
Sirajul Haq,
and on top,
top Moinuddin Ahmed.
Moinuddin Ahmed is the other person.
Yes, my lord, he received, my lord.
Next, my third column, Izazul Haq.
The second is Sirajul Haq.
Yes.
Where are your names in the 3G?
As per their affidavit, what happened, my lord?
Whatever their affidavit, what they say. Therefore, I don't trust their affidavits. My question is, where is your name in the 3G?
My lord, in next, my lord.
Where?
Next, my lord.
Eight?
Page 60.
You do one thing, you return that 1676 amount to the department,
1676.
as you have said so. As regards 1671, let him go and file an PH4.
Till
Go
date
and
we
file
have
a
not
PH4.
received, my lord. Only
They
I,
will decide it, and if they are, you are entitled to, you will get the money.
One thing, my lord, here what happened, my lord?
How can we decide?
No,
When here the
I'm-
3G1 does not
no,
contain
my lord,
your
I am not on that point, my lord. My case is for the arbitrary act on part of the Kala, my lord. Arbitrary act on part of the Kala and circle officer, my lord.
Did you make a claim prior to that you are in possession?
Yes, my lord, that has been verified by the authority, my lord.
Where?
Yes, my lord, I have annexed all documents.
Where?
From page 15. This is the Sita for the riot, as a riot, my lord.
Page 15.
16, 16, original one.
Ah.
Riot Odhikar, my lord. That is the second row. Third row, my lord, 9. My father name.
After this,
After this, my lord.
page 20, what have you done?
Yes, we have submit all documents, my lord.
Where?
Before the circle officer, my lord, as per this notice. And what happened, my lord? There are prior to that, my lord, one my lord agreement was executed. This is the admitted fact, my lord. That is at page 23.
Page
23. This is the agreement. This is admitted by the authority, my lord, in their affidavit, my lord. This is to certify that in DAG number 1671, plot of land covering so and so hectare will be divided among two parties. Each amount.
No, this is by the circle officer.
This is
These are all your proofs to get the money.
And-
You ask for that money, you'll get the money along with interest. Interest will go on. If they don't make the payment, you claim the interest.
well, authority may be directed to take penal action against him because he has submitted the affidavit.
Oh, they will take it. That I will pass an order.
Yes.
He is going to return 1676.
Yes.
my lord.
He says that he has categorically says that he is not going to take the money for Kobostan.
Yes.
As the other one, he has put an affidavit wherein it says that one Ojit Ali, the spelling must be wrong. It should be Aziz Ali or something.
Yes, madam. Alia Ali, father was.
Ojit Ali and one another person, the petition number 2 are in occupation. This may be a document which will be able, you can prove it. In fact, when there is a dispute, it is not seen that a Kala has entertained the dispute.
No, we have no dispute, my lord.
Understood. You don't have a dispute when you are before the circle officer.
No.
Yes.
No, my lord. Actually, what happened, my lord? At the time of the disbursement of the fund, my lord, a apportionment, my lord, he has done everything. Submitted the affidavit.
You have submitted affidavit.
He has.
He has submitted affidavit. So
Affidavit-
that affidavit,
no.
now he says this is contrary to his affidavit. These are the things which you take it up under 3H4. Take it up. How it is to be done. Then only the thing will happen, they will recover it. Let the order, the district judge will pass an order. He will pass an order that he has illegally taken it. Now, in the Sita, the possessors are names are shown as so and so. Now, in this particular document, which has been enclosed as Annexure Roman 3, there is no mention of your name.
No, no, no.
Yes, they may have done some mischief.
And my lord, in this regard, my page, as per page 16, my lord, one Moniruddin also name is reflected, but he had not made party, my lord. Whatever, my lord, Moniruddin received about more than 50 lakhs, my lord. But my lord, he filed it petition.
Where is this? Jurhat?
Dorong.
Oh, Dorong. Dorong also. I think Jurhat was the sole instance.
Yes.
Now Dorong also has.
This is
Dorong,
the
because of now the the foreleaning. Because of this foreleaning, no.
Bypass. Bypass.
Okay, bypass.
Lord, the page
Anyways,
18.
let me deliver the.
Well, one thing, my lord.
No. Rest will go there. Heard Mr. D. Bulwer, the learned counsel, appearing on behalf of the petitioner. Mr. Ms. P.R. Mohanto appears on behalf of the respondent number 1. Mr. N. Das appears for respondent number 2, 3, 4, and 4. So appears
I'm
for
saying.
respondent number 5. The present petition has been filed by the petitioners, being aggrieved by the inaction on the part of the respondent authorities, more particularly the respondent number 3, in not releasing the compensation in respect of their land, or in respect of their rights over the land covered by DAG number 1671 and DAG number 1676, number 1, of Pata number 1 within Moza, within Rongamote Moza lot number 3, in village Horuthekarabari under Moza Rongamati lot number 3 within Mongoldoi Sodor Revenue Circle in the district of Dorong, Assam. The petitioners herein claim that they have possessory rights over the land covered by DAG number 1671 and 1676 of Patta number 1 of village Hekini Likhi Diba Kub. The grievance of the petitioner is that while dispersing the amount, the total compensation was paid to the respondent number 5 and the respondent number 5 did not divide their share, his share, did not in turn make payment to the petitioner, though he had categorically submitted an affidavit before the competent authority of land acquisition that he shall do so. This court duly takes note of the copy of the chitta pertaining to DAG number 1671, wherein the names of one Mujid Sheikh, names of Mujid Sheikh, Moniruddin and Ajit Sheikh, bracket Amir, have been mentioned as in the column of Riot / Adhyar. This court also takes note of that in DAG number 1676, the names of Mojid Sheikh, Moinuruddin Ahmed, and Ajit Sheikh, bracket Amir, have also been recorded in the column of riot oblique adhyar. It is also relevant to take note of that the circle officer Mongoldo Revenue Circle had issued notice to the petitioners as well as the respondent number 5 on 1/9/2022 for determination of their status in respect to the land covered by DAG numbers 1671 and 1676 of Patta number case of the petitioner, it is the petitioner also submits that objections were duly filed before the respondent number 3. That the compensation amount in respect of DAG number 1671 and 1676 was disbursed to the respondent number 5, and the respondent number 5 is not willing to make payment to the petitioner. The complaints, however, having not been disposed of, the petitioner have approached this court by filing the present writ petition. This court also finds it relevant to take note of the affidavit filed by the respondent number 5(1). Wherein the respondent number 1 duly admits that the compensation amount ought to have been divided between the petitioners and the respondent number 5. And in that regard, have also endorsed to the agreement so entered into by and between the petitioners and the respondent number 5 in presence of the circle officer. It is further mentioned that on the basis of the affidavit so filed by the respondent number 5, who agreed to divide the share of compensation amongst the petitioners and the respondent number 5, the amount of compensation in respect of the total compensation in respect of DAG number 1671 and 1676 was disbursed to the respondent number 5.
76 not disbursed.
1676 not disbursed.
76 is under stay, my lord. Of rest, 76, 1676, the amount 45 lakh, 1,000, it is not disbursed because this is stayed by your lordship.
Here is a complaint petition filed by the writ petitioner. To that effect, my lord?
Oh, yeah.
The amount has not been
Otherwise, my
disbursed.
lord, interim order is also operating, my lord.
1671 was disbursed. It is also mentioned that in view of the stay so granted by this court, the amount of compensation for DAG number 1676 have not been disbursed.
Before the stay of this honorable court, my lord. Before, after receiving the complaint petition from the writ petitioner, it has been stayed.
It is, however, seen from the affidavit filed by the respondent number 5 wherein he has stated that the respondent number 5 do not wish to claim any compensation in respect to DAG number 1676 or Patta number 1, as the said land is at Kobostan. However, insofar as dark number 1671 of patta number 1, which is the subject matter of the present consideration, it is the specific case of the respondent number 5 that though the petitioner number 2 as well as the respondent number 5 were in occupation of the land in dark number 1671, patta number 1. However, the petitioner number 2 have sold the land to one Moinuddin Ahmed.
Yes,
Is his submission statement. And the remaining portion is under the possession of the respondent number 5. The learned counsel, referring to the said affidavit, submitted that that this very aspect would also be seen from the 3G estimate which have been enclosed by the respondent number 1 to the affidavit as Annexure 1, wherein the name of Moinuddin Ahmed, what is the spelling?
Moniruddin Ahmed.
M-A,
MONIUR.
remaining spelling?
My lord, there is a Monir, MONIRU, double DIN, Moniruddin.
Ahmed. And the respondent number 5. To a pointed query made by the petitioner, by the court to the learned counsel appearing on behalf of the respondent number 5, that if that be the stand of the respondent number 5 in the affidavit, why did the respondent number 5 submit an affidavit stating inter alia that the petitioners as well as the respondent number 5 are in occupation of the land and he has agreed to divide the compensation? The learned counsel appearing on behalf of the petitioner, respondent number 5, submitted that the said affidavit was prepared without the proper knowledge of the respondent number 5. And as such, the said affidavit cannot be given any importance, cannot be relied upon. It is the specific submission of the learned counsel that the respondent number 5 is not accustomed with the English language. This court have duly heard the learned counsels appearing on behalf of the parties. First, from the materials on record, it is apparent that insofar as the compensation for in respect to dark number 1676 of patta number 1, the said amount have not been disbursed. And the respondent number 5 also do not wish to claim on the said amount as is specifically mentioned in the said affidavit, in the affidavit filed before this court. However, in view of the affidavit filed by the respondent number 5, the 3G estimate which have been enclosed as Annexure 3, Roman 3 by the respondent number 1, the affidavit filed by the respondent number 1, as well as the complaint so filed by the petitioners, shows that there is an apparent dispute as regards the entitlement of the amount of compensation in respect of dark number 1671 of patta number 1 of village Horu Thekerabari. This court duly takes note of section 3H4, 3H of the National Highways Act 1956, From a perusal of the above quoted, from the perusal of the said section, it is apparent that the power, the authority to of the competent authority of land acquisition to disburse the amount of compensation so deposited in terms with section 3H1 is when there is no dispute as regards the entitlement. However, if there is a dispute, such dispute cannot be adjudicated by the competent authority of land acquisition. And the same has to be adjudicated by the learned district judge, within whose jurisdiction the land is situated. National Highway. মানে মেইন এক ৰাতিপুৱা গধূলি এইখনকে লাগিলে। Under such circumstances, the incident with petition therefore stands disposed of with the following observations and directions. Respondent number 3, who is the competent authority of land acquisition, is directed to refer the dispute between the petitioner as well as the respondent number, petitioners and as well as the with the petition dispute between the petitioners and the respondent number 5 to the learned district judge, Dorong
Mongoldoy.
at Mongoldoy, for adjudication as to whether the petitioners herein are entitled to the compensation in respect of DAG number 1671 of once pata number 1 of the said reference be made immediately forthwith upon receipt of a certified copy of the present judgment. Number 2, taking into account that there is a dispute and the respondent number 1, respondent number 5, counsel for the respondent number 5 have disowned the affidavit so far submitted, on the basis of which the amount of rupees so and so. How much was the amount?
5,07,022.
Uh,
5,07,022.
was disbursed to the respondent number 5, comma. The respondent number 5, 3, shall take effective steps for recovery of the said amount so that the same may be deposited before the reference court
Yes.
in terms with the indemnity bond so submitted by the respondent number 5 at the time of submission, at the time of claiming compensation of the said amount, claiming the disbursal, claiming at the time of to thereby permitting him to thereby at the time of claiming the compensation, the claiming the disbursement of the awarded amount. Yes. The parties would be number 3. Taking into account that there is no dispute in respect to DAG number 176,
No, no,
1676 of Patta number 1 of so and so. And it is the categorical stand of the respondent number 5 that the respondent number 5 do not wish to claim any compensation in respect of DAG number 176 or 1676 of Patta number so and so. The respondent number 3 shall disburse the amount to the petitioners subject to the satisfaction and the submission of necessary documents as required for the disbursal of the said amount. Number 2. The rights and claims of the petitioner, the inter se rights between the petitioner and the respondent number petitioners and the respondent number 5 is kept open, which shall be decided by the learned district judge Dorong in accordance with the provisions of law, uninfluenced by the observations made herein above. No question. Yes, what is this? Yes, you have challenged some in retail outlet being issued.
My lord, this is off license of liquor shop, my lord. Pursuant to the NIT, we had participated in the bidding process, and my rejection is at page, my lord, 171.
Yes. Why?
171.
Site plan submitted is not certified by the engineer.
The requirement was that site plan has to be submitted by.
Now I remember. That was by some architect.
Yes.
Even no case.
My lord,
No case.
my lord, assuming or keeping my claim aside for a moment, my lord. My lord, may kindly come to the affidavit filed by the respondents. Now, what has happened here? The private respondent who was awarded the license did not comply with the requirements of the tender bid. That is, they have not filed the form C that is required to be filed in the e-submission bid. Now, what if our lordship comes to page of the affidavit in opposition?
Whose affidavit? For respondent number 4.
One is for respondent number for both the affidavits, my lord.
By respondent number 6.
One is respondent number 6, and first of all, my lord, may take up respondent number 4.
Yes, what does he say? Tell me.
Here, what they have done, in violation of my of the rules of Article 14, this bid which this document which they are not filed with the e-bidding process was taken behind the back by hand. They have admitted that.
Where?
This is
What document?
This is a Form C. That's the essential part of the bid document. Form C.
What is that document?
Form C is at
Annexure C.
Form C is at page. This is a compilation of all the
What is Annexure
submissions.
C? What is Annexure C?
Page 50, my lord.
Checklist.
Checklist. That is essential part. I'll come to that, my lord. That is an essential part of the document. Page 50 is an essential part of the document. Page 50, and it's
That's a checklist.
checklist, my lord.
My question is the checklist a mandatory part of the document?
My lord, because
Where?
in other districts, my lord, in other districts also, the same.
Not on there. Here, let us see from the terms that of the year that the checklist has to be brought.
My lord. In the affidavit, they have not stated that. They have not stated this.
No, in this tender document, wherein it is said that the checklist has to be. Show me that.
There's no, because there's no direct mention of that of annexure C or annexure A or annexure
You
B.
want this court to become the tendering authority?
No, my lord may first come to.
So we close.
Page
That day
17.
we have heard it. On that day you sought for time only.
My lord, the matter was not heard because of the paucity of time, my lord.
No, that day I have heard it.
Yes, my
I
lord.
knew it. The moment I saw you, I remembered about the architect. And that also architect whose license have not been extended on the date on which it was.
My lord,
Isn't it?
that is the allegation. That is the allegation, but we have filed a rejoinder affidavit stating that we have.
But it has, the architect is not engineer. You should have given it by an engineer.
My lord, there has
We
been.
apply now Ronak, paragraph 7.
No.
Matter.
My lord, keeping aside, assuming that I have not complied with the necessary condition of tender document. Now, even then, annexure C is a very vital document. It's a checklist of.
You are saying it. Nobody is saying it. Neither the tender document is saying it.
But in their affidavit, they have been very evasive. What they say is that we have taken it by hand.
They have
In
given
the
it
hard
as a
copy.
checklist.
In the hard copy. Now,
Checklist, they don't consider it to be mandatory. What do I do?
because in other districts, in the same liquor licenses, bidders have been rejected because of non submission of annexure C. That is at page, my lord, 364, annexure 8, 364.
360. Where?
364. Page 364.
Where? The verification of the submitted by the bidders and physical verification of the based on the document that the bids are accepted or.
This is
rejected
Lilima
is
Soikia Budwa.
are considered final. Sorry. Neil. It's accepted. Also, as per the duly filled C is not submitted. So here, it has not been submitted.
Yes, my lord, in the online bid, my lord, it is not.
Now, it was not submitted on that date. They have accepted it. If they had submitted it, they would have accepted it.
There's
How
only-
do I know?
There's only one way of submission, that is the e-bidding system. It cannot be the
For
lacuna.
example, earnest money deposit.
The
Now, this has been done by somebody else.
lacuna cannot be filled
By
up by
Kamrup Metro.
supplying in the hard copy.
Kamrup Metro, it has been done. Now, you see, what does the commissioner say? Commissioner of Excise, what do they say? Why that all the districts are having different rules?
In this case, the duly filed lawsuit, it is not filed properly lawsuit, that the Kamrup Metro rejection order lawsuit, it is duly filled annexures is not submitted.
Submitted.
It is not properly filed.
And here in this case, it has not been filed already. Altogether, it has not been filed. Annexure C, the private respondent has not altogether not filed annexure C. And to fill up this lacuna.
No, they have submitted it.
No, that is by
Hard copy.
that in the hard copy, not by online bidding.
Yes, your lordship, online, your lordship may kindly come to page 50, your lordship, for a moment. That's the annexure C. Annexure is very critical. What are the documents to be uploaded, your lordship?
That is it.
Annexure C is not there, your lordship. And when it is not there, why should I upload it? But I have submitted the hard copy. Documents required to be uploaded, very specific, your lordship. These are the documents asked to be uploaded, and I have uploaded, your lordship. So far as
Checklist.
But that is a mandatory part of the,
Why do you say so? Show me a term.
because it's a part of the bid document, my lord.
So what? Is it required that annexure C has to be submitted?
It is, my lord.
Where?
It is, my lord, because
No, you cannot say so unless you say it there.
Now here, if, as per the district commissioner, my lord, the authority says the respondent,
Thakur, I give him 5 minutes to argue for his self-satisfaction.
the respondent number 6 has duly submitted annexes C in the hard copy of the
4:15 we will
technical
get
bid
the
as per clause 10 of the bid document.
You in the meantime, give me that Ronak judgment of 7. Yes, you argue for 5 minutes.
My lord. Now, in the affidavit of the private respondent, they have said, now here they have said, the state has said that we have accepted the annexes in the hard copy. Here they have said they have duly filed. There are two different things, my lord. Duly filed means through online bidding, it has to be through online bidding. They have not, because the sanctity of the online bidding has to be there, my lord. Otherwise, there's no point in having an online bidding system. Your lordship had yourself observed in another matter, my lord, this is regarding the mining this matter. This is, my lord, in 1466 of 2023, my lord. This is in the Ajit Bora matter. In para 43, your lordship has also said that, my lord, in other matter, the learned single judge had allowed that all hard copies may be filed to all the parties. In that case, my lord. So my lord had observed in para 43 of their judgment, my lord,
What happened? Appeal was filed, what happened?
appeal was upheld. The learned single judge order was upheld. The Supreme Court also upheld that judgment, my
The
lord.
matter finished. Then
No.
what happened? What did they say out there?
In
Did they
40
say deal with Annexus C?
In 43, my lord. If a lordship likes to peruse this judgment at 43,
Now they have 3 more minutes.
it's at page 26 of 32.
This is matter pertaining to what? Each
Page
paragraph?
26. Page 26, para 42.
Para 40.
43, I'm sorry. Page 26, para 43.
Not satisfied.
Well, there's another similar matter which was decided by this coordination.
Unless you show that Annexa C was required. No, this is okay. This judgment is okay. This judgment is in terms with the other judgment. What is the name of that judgment? I forgot. Got that judgment somewhere. Let me see. It happened as well. Anyway, that is not beside the point. Okay,
My lord, we can come to page 78, my lord.
let us see the terms which are required. It says here. When's required to be submitted.
My lord, if I may submit, if this is not a required document, they did
Documents
not have submitted the
comprising
hard
the
copy.
bid. Now, whether it says Form A, say duly filled by Form A. Where is it says about C?
It is
D.
silent, my lord.
Then matter over. Chill. Heard Mr. Sharma.
That's 78, my lord.
No, it's okay. Mr. Sharma, I have given you more than that time.
Only 2 lines say at 78, page 78. Page 78, para 10, my lord.
Yes.
Preparation and submission of bids in a two-cover bid. Language
The
of,
same document, isn't it, at page 29?
my lord. At far below, my lord, at the last paragraph, the bidder shall carefully go through all the documents and prepare to upload the scanned documents in portable document format in a designated link in the web portal as the technical qualification bid. The bidder shall submit both technical and financial bids through online.
So this we find it at paragraph, page 33.
33 also.
Same thing. No, but bid comprising, documents comprising the bid.
My lord.
It says about Annexure A, Annexure B. It doesn't say about Annexure C.
NSSC. But that is the compilation which is required.
It doesn't say about Annexure C. You bring the other case with interfere. Or Mr. R. Sharma, the learned counsel appearing, senior counsel assisted by so and so, appearing on behalf of the petitioner. The Goswami
1 to 5 lots.
appears on behalf of the respondent numbers 1 to 5. Mr. S. Bhattakur. For 6. Said by Mr. Digugoi. Appears on behalf of the respondent number 6. The present petition has been filed by the petitioner. Being aggrieved, take a seat, Mr. Sharma. By the decision of the Technical Evaluation Committee dated 2/4/2025, whereby the petitioner's bid has been held to be technically non-responsive. And the respondent number 5, after the financial bid evaluation was carried out, was granted the license, granted the Indian-made foreign liquor retail off license. The brief facts of the instant with petition are that the office of the district collector, Tinsukia district, had issued a notice inviting tender dated 4/1/2025. And thereby inviting e-bids for grant of Indian-made foreign liquor retail off license in the district of Tinsukia at the locations so mentioned in the list of shops at page 5 of the said e-bid document. A perusal of the PEB document, which have been enclosed as Annexure 1 to the writ petition, shows that at clause 2, the eligibility requirement for participation in the bidding have been mentioned. Clause 3 stipulates the terms and conditions for the grant of the IMFL retail off license. Clause 6 is very relevant, taking into account that the said document, said clause stipulates the documents comprising the bid. From a perusal of clause 6, it is seen that a bid was required to be submitted into two parts. In two parts. One is the technical and other is the financial bid. Amongst the various documents which are mentioned at clause 6, there is a requirement where is that? It has to be by way of an engineer.
That is in the page.
It is 53, column 12.
Hmm?
Yes,
There.
Annexer C, page 53.
Page
53. Serial number 12. Your Lordship.
stipulates that there is a requirement of submission of a document which would be the copy of the plan of the building which the bidder intends to use or construct for his shop. This court further finds it relevant to take note of that clause 10 of the bid document stipulates about the preparation and submission of bids in a two-cover bid. Tell me, where do I find Annexer C in the bid document?
Page 50.
Huh?
Page 50.
No. In the bid document, it's a checklist, like Annexer A is there, Annexer B is there. Where is Annexer C?
Annexer C is, my lord,
Somewhere it will be mentioned somewhere. Because it is the requirement of having an engineer is only on the basis of the Annexer C. So therefore, where is that Annexer C? Because in the bid document which is required to be submitted, there is no requirement of an engineer. So there has to be correlation between Annexer C with the bid document. Otherwise, if there is no correlation, the bid document, this Annexer, this consideration could not have been taken into consideration at all. Somewhere it will be there. Annexer A is duly mentioned at page 29.
notes.
Then so
Annexer
and so.
D.
Annexer undertaking Annexer D is mentioned. Then Annex undertaking in E is mentioned, affidavit in annexure B is mentioned. Where do we file annexure C?
Page 95.
Page
95.
What is this?
It's annexure C, madam.
No. I'm not on that. See, you're not understanding this. Unless annexure C is correlated, then there is no requirement of the engineer making that submission.
In the
See, annexure C only says that the site
plan.
verification has to be signed by the engineer,
engineer.
and you have been given by somebody. Now, if you see, therefore, kindly see this. Come to page 30.
It only talks about a site plan.
Copy of the plan of the building which the bidder intends to use or construct for his shop. So you have given the site plan.
Site plan.
It does not say about the engineer.
No, madam.
So therefore, where is annexure C? It cannot be based upon unless it is there here. So therefore, you may have a good case on that. You are not arguing it.
No matter, in page 31, it is only given a site plan.
You have to only give a site plan. But
Site plan.
where do I correlate annexure C with this document with this bid? Where? Mr. Goswami, where is it? We see an ABC,
Yes.
AB, DE, everything. But where is C? Where? Annexure B we find. Where do you find annexure C correlating with the bid? If it is not this clause, you could not ask for the engineer. Look into it, both of you. We'll have it on some other day.
Lots.
This is a very important thing. and you look into it, if necessary, file an additional short affidavit.
Madam.
Because otherwise your case goes against him. You are arguing a case which is against yourself, that means. Asking for a compliance to Annexure C, if Annexure C is not a part of the bid document. Is given. I couldn't find anywhere. It is strangely. And can you, on the basis of the checklist, incorporate a term? Because the main body of the petition does not contain that term. And if we interfere with him, then the entire technical process goes. Then it will have to go for a, we may relegate you to look into his bid, everybody's bid, and finish it off. His financial bid is with you.
Yes.
That will be considered then. There won't be a fresh bidding. Don't expect that.
Look,
Are you the highest bidder?
I'm the highest bidder and much higher. He's 10 lakhs, I'm 45 lakhs.
But you find out this,
Madam.
because why are you enclosing two sets?
No, one set we have enclosed, that is the bidding documents of the respondent number 5, madam. Is
No. Why have you enclosed these document at Annexure 1? And what is the office of the other, the second document?
That is my,
Why have you enclosed the
his
other one?
document.
that is my documents, Your Lordship. He has also annexed.
I've annexed his documents also.
No. This is your document. No, it is, this is the bid document. Why, what is page 60?
Well, madam, I have annexed what I have filed,
Here there is
and
nothing.
him also.
Here it is nothing maintained, it's a blank document. Page 15 to page 59 is a blank document.
Madam.
Why have you enclosed page 60 onwards, the same document? Why? It is also a blank document. Why are two documents here? So it is the same document. So
Same
there is only one document which I have read.
Yes.
Next one is the main bid document.
Madam.
There I could not find. We have this on some other day. I need not advise you further. Just find out. So you have a case on this, if you can find out. How is Annexure C there? And if you cannot connect Annexure C with this document, then there is no term for the site engineer to sign. Mr. R. Sharma, the learned counsel, the learned senior counsel appearing on behalf of the petitioner submits that the reason why the petitioner's bid was rejected is not a condition which is mentioned in the bid document, in as much as clause 6 of the bid document do not stipulate the requirement that the site plans should be certified by an engineer. Further submitted that merely mentioning in the Annexure C without there being a stipulation in the bid document and there being no correlation of the Annexure C to the bid document, the rejection of the petitioner's technical bid on the basis of the stipulation mentioned in Annexure C, more particularly at serial number 12, is unfair and arbitrary. He therefore submits that he may be permitted to bring on record the said aspect by filing an additional affidavit. Full stop. Mr. N. Goswami, the learned counsel who appears on behalf of the Excise Department, shall also apprise this court on the next date as to what is the correlation between Annexure C of the bid document with the contents of the bid document, as it prima facie, as this court prima facie do not find any term in the bid document referring to Annexure C. Full stop. List this matter when?
Any day, my lord, so this 1 week, 10 days.
This matter again on 25th of too long. 11th of August 2026. The interim order passed earlier shall continue till then.
Obliged.
Mr. Triple S Rahman at 4:30. What is it?
My lord, I have made this, my lord, for lordship.
You know, his husband is a.
What is this?
Well, I have, my lord, made this for your lordship, my lord.
My goodness, I have never been given a gist or written.
My lord, what happened my
unless
name?
I have asked, and once I have asked, and they have given so much of faulty gist.
My
I
lord,
stopped asking.
my lord, at page, my lord,
What is your case? Give me a simple example. What's your case?
my
What
lord,
do you
my
want?
name, my lord, my land was acquired, my lord.
Huh?
My land was acquired, my lord.
To consider representation dated so and so. Yes, now why? What has happened? No payment has been made.
Yes, my lord. Since 2018, my lord.
Now, is your name in
At page 28, my lord.
Wait. Your name mentioned out there in the tree,
Yes, my lord.
your land?
Yes, my 28, page 28, serial number 8, my lord.
Albianglong, Borjan,
Yes, my lord.
your name, Raktul Terong. Okay.
Yes, ma'am.
Then? Now what happened?
My lord, Onita Mess, my lord.
Huh?
She
Is
filed
it
a writ.
the notification under section 3A
My lord.
or 3D? Or this is 3D?
3D, my lord.
Now you have not received compensation.
Not compensation, my lord.
That is your basic case.
My lord, yes.
Then why do you need a gist for this court?
My lord,
There is another big problem. Somebody has filed some case.
yes, my lord.
Yes, what was that?
Another person, my lord, this plot of land, my lord, another person claimed a compensation, my lord. She filed a repetition. My lord, in the repetition claimed that the land belongs to her, my lord. She is in possession of the land. My lord, accordingly, the honorable court, my lord, passed the order, my lord, in that particular case, referring the matter to 3H3 and 3H4.
3H4.
My lord.
That order, I could find it out here. Somebody.
Yes, my lord.
What
Yes,
is
my
that?
lord.
Annexure
My lord,
C?
yes.
That is
Annexure
at,
C?
that is at page 51.
Now what has happened?
My lord.
Now it is pending before the Kavianglong district.
My lord, it cannot.
He has not maintained it.
PS3, my lord, it cannot be, my lord. The land compensation, GRAT compensation has been paid to that particular person, my lord, who filed a petition. Petitioner has not objected to it. But the land compensation payment to the petitioner, my lord, that is objected by the, my lord, that particular repetition of, my lord, repetitioner of that particular repetition. That is a repetition number, my lord. Not 51.
But
6453, my lord. Now, my lord, it is required to be referred to the civil court as per the 3H4 that it could not be apportioned between
the reference is to be made by your competent authority.
But this case and the review petition both are pending, my lord. As the case is pending before the Honorable High Court, my lord. So we are not processing for sending it
Who
back.
has filed a review?
My lord, Onita Mes, my lord, filed a review petition.
For what?
For that the claiming, my lord, land compensation amount also, my lord. That review petition ultimately
This
dismissed,
order
my lord.
was for what?
That review petition was dismissed, my lord.
Huh?
That review petition dismiss.
Review petition dismissed.
No, review petition,
But
but
therefore, now the thing is you are.
To refer it to the civil court, my lord.
My
If
lord.
the petition is disposed of, my lord, the petition, as the petition is pending, my lord, so we are not taking any.
No, you, I pass an order.
My lord, my lord, my lord.
As an order has been passed in the other writ petition and here also, there is a
Well-
dispute as to who is the owner.
My lord,
Although in the 3D notification, his name.
name is
there.
there, my lord.
So the question is as there is a dispute as regards the entitlement of the compensation.
My lord.
But the ADC, the competent authority of land.
My
My
lord,
lord,
my
my
lord.
lord.
Under 3 is 4, my lord.
Mr. Triple S Raman, for that matter, you have got a written argument also.
Well, for your convenience. my
And
lord.
it is bigger than the writ petition? No.
All facts are there, my lord.
Heard Mr. Triple S Rahman, the learned counsel appearing on behalf of the petitioner. Mr. J. Union. So appearing for union. So and so appears for respond number 2.
Free, my lord.
So and so appears for respond number 3. Are you appearing for 7 also, no?
My
You're appearing for 7 also. Kala?
lord, 6 and 7.
No, you're appearing for 4 also. 4, 5.
Well.
Mr. J. Sutia, the learned senior counsel, as well as the standing
4, 5.
counsel of the Karbi Anglong Autonomous Council, assisted by so and so, appears on behalf of the respondent number 427. The dispute in the instant proceedings. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in payment of compensation to the petitioner in respect to the land acquired at measuring 0.3880 hectares covered by DAG number 33. Of patta number?
My lord.
Huh?
Patta number, my lord. Patta number 146, my lord.
AP or what? AP or AP?
My lord, that is at page, my lord.
Where's your land?
My lord, 38, my lord. Page number 38, my lord. And page number 36. Annual Khiras Patta, my lord. Page number 36.
AP patta number 241. A village, Koragaon, block number 2, Borjan, in the district of Karbi Anglong, Assam.
Page 36, another document.
This court duly takes note of that the petitioner's name features in the notification dated 22/3/2018 issued in exercise of the powers under section 3D, capital D, of the National Highways Act. During the course of the hearing, inquired with Mr. J. Sutia, the learned standing counsel of the Karbi Anglong Autonomous Council, as to why the petitioner not been paid the compensation.
39.
The learned counsel, referring to
36 was on.
the order passed in WPC number 6453/2019, submits that there are other persons who are also claiming compensation in respect to the said land. And therefore, there is already a direction passed by the learned coordinate bench of this court in the order dated 3/11/2022, passed in WPC number 6453/2019,
Lordship.
Wherein?
Lordship, look at page 51. What is the direction of this court earlier?
I've read it.
Page 51. Directed the petitioner to approach the civil court.
Why there is already a direction passed by the for adjudication of such dispute in the proceedings under section 3H4 of the National Highways Act 1956. The Learned Standing Council further submitted that this reference have also been not made in view of the filing of the present writ petition. This court have duly perused the order dated 3/11/2022, passed in WPC number 6453/2019 and WPC number 8386/2019. A perusal of the said order do not refer to, do not stipulate, mention as the land against which the petitioners therein are claiming compensation. And as such, it is difficult to assume that the said directions passed by the Learned Coordinate Bench dated 3/11/2022 in WPC number so and so and so and so is in relation to the land which the petitioner, in respect to which the petitioner's name appears in the notification issued under section 3D of the National Highways Act. Be that as it may, this court duly takes note of section 3H of the National Highways Act 1956, which stipulates that pursuant to the payment of compensation by the central government in terms with section 3H1 of the Act of 1956, the competent authority is required to disperse the compensation subject to there being no dispute as regards the entitlement or apportionment thereof. However, if there is a dispute, it is the responsibility of the competent authority to make a reference to the court of the principal civil judge of original jurisdiction, principal court of principal, what is that term used? Principal judge of
original jurisdiction.
Principal civil court of original jurisdiction, within whose jurisdiction the land is situated. So, taking into account the above, this court disposes of the instant writ petition with the following observations and directions. This court directs the respondent number 7 to disburse the compensation to the petitioner in terms with section 3H3 of the National Highways Act 1956 if there is no dispute raised as regards entitlement and apportionment by any other parties. If there is any dispute raised as regards the petitioner's entitlement or for the apportionment of the compensation in respect to the land described, covered by DAG number 33 241 the respondent number 7 shall refer the matter for an adjudication to the court of the learned district judge Karbi Anglong The learned district judge Karbi Anglong thereupon shall decide the said dispute in accordance with law. With the above, the writ petition stands disposed. No like that. The problem is that, Mr. Suti, the earlier order do not mention the Dagnam.
My lord, and they to mention that the petitioner should approach. And the
That cannot happen.
petitioner cannot, it's a
Because here the
computer-
word is
But
getting
petitioner
said
means my lord, auditor mess, who has filed the writ petition, my lord, not me, my lord. Not me, my lord. Petitioner should-
Obviously, if you would have done it, you would not have committed that mistake.
All right.
Yes, what is this? What is this?
Lordship, I have challenged the order of,
Diswas. Oh, one matter has been disposed of. Ruby Diswas. Now your case is what?
Lordship,
Something about that matter about, yeah, why haven't you got under section 9 or 10?
nine, Lordship,
9.
9. Because my case is that it is a government land, Lordship.
Put in a fact.
Yes, Lordship.
Go there, put in a fact.
Till then,
End
Lordship,
out there 1 year.
till then some protection, Lordship.
I'll give you for 15 days from today. Because I can't give you more, 15 or 12 days, 12 days.
12 days.
I will give you only 12 days. Because I can't enlarge what the statute gives. Heard Miss P. Vachachi, the learned counsel appearing on behalf of the petitioner. Mr. B. Chakraborty appears on behalf of the respondent numbers 2, 3, 4, 5, 2, 3.
2, 3, 4, lordship.
And 5, 6. S. Doctor appears on behalf of the respondent number 1. And Mr. Endas appears for the respondent number 5,
6.
and appears on behalf of the district administration of Kamrup Metro. Because there are 2 5s.
We have 2 5s.
The present writ petition has been filed by the petitioner challenging the order dated 4/6/2026-25 passed by the estate officer of the NF Railway Lamding in exercise of the powers under section 5 the Public Places of Unauthorized Occupants Act 1971.
Yes, Lordship.
The case of the petitioner herein is that the railways, the land in question do not belong to, it cannot be treated to be a public premises within the ambit of the Act of 1971, inasmuch as the land in question is a land of the government
Yes, Lordship.
of Assam.
And I have applied.
Is a government cast land. And the petitioner have duly applied seeking allotment,
That is pending.
which is presently pending. This court have duly taken note of the impugned order dated 4/6/2025 and the issues which have been raised by the petitioner before this court. Look, the issues which have been raised are questions of facts as to whether the land under the occupation of the petitioner are railway lands or government cast lands. There's an appellate remedy available against an order passed under section 5 of the Act of 1971. That is, an appeal to the district judge within whose jurisdiction the land is situated. That would be the district judge. Where was I?
Kamrup Metro.
Where is it? Kamrup
Metro.
and is here.
Yes, Lordship.
It is the district judge, Kamrup Metro at Gauhati. Considering that there is an alternative and efficacious remedy, this court is not inclined to entertain the present writ petition, for which the writ petition stands dismissed. Before parting with the record, this court observes that as the instant writ petition is being dismissed on the ground of being not entertained, the petitioner shall not be precluded or prejudiced to approach the learned district judge Kamrup Metro, challenging the order dated 4/6/2025 passed by the respondent by the estate officer NF Railway Lamding. Why Lamding has passed that?
A division comes under the Lamding division.
But we find out here
The Rangia, thereafter, after this Rangia division, Gauhati comes under Lamding division.
so this person has to go to Lamding.
No, for he can file here.
Because land is here, Lordship.
Land is here.
Land is here.
The officer is in Lamding.
Yes.
Officers in Lamding
He has to go to Lamding.
for filing the reply to them.
This court also takes note of that if this court also takes note of that there is a period of limitation for filing the appeal, and as this court is not entertaining the instant writ petition on the ground of availability of the alternative and efficacious remedy, this court observes and directs that in the circumstance the petitioner files an appeal within 12 days from the date of the present order, appeal be considered taken up on merits for consideration without insisting on the question of limitation. Next. This court also observes that if the petitioner is not being extended, also observed that there was an interim order that the learned coordinate bench of this court had passed an interim order, thereby protecting the petitioner from eviction. It is the opinion of this court that if the petitioner is relegated to the appellate authority and some protection is not granted for a period of 12 days, the entire exercise of filing the appeal would become infructuous. Accordingly, the interim order which had been passed by this court on
12/6/2025
12/6/2025 shall stand extended for a period of 12 days from today. This court further observes and directs that the extension so granted to the interim order and shall not influence the learned district judge to pass, and the learned district judge, Kamrup Metro, shall be at liberty to pass such interim orders as deemed fit without being influenced by the present extension. It line to Milari was
Obliged.
Well, item 8 on neither analogous. Well, I received a copy of the affidavit in opposition filed by the government in item number 8, to which I required time to file affidavit reply. Madam.
What is your case?
Yesterday only I received the copy, Madam. So I would like to file a reply to it.
What are you asking for?
Well, I am challenging the
Order dated 3/6/2025.
that is page 64.
Page?
Page 64. The string order passed by the DC. In fact, my lord, that deed writing license has been cancelled.
Page?
Page 64, my lord.
So and so and so. Now they have filed affidavit.
Well, yesterday at the 11th hour, I received
Why
copy.
two writ petitions, Mr. Counsel?
Mal-
Why are two writ petitions?
both the petitioners' licenses were cancelled by the Deputy Commissioner.
Understood, but why two writ petitions?
In the first case, cancellation order is under challenge. Subsequently, this honorable court interfered with the and directed to pass a speaking order. Accordingly, this 64 page 64 order has been filed, which was is under challenge in writ petition 5611/2025.
So therefore, the first writ petition has become infructuous.
No, let the matter,
Yes, yes.
two matter maybe take together so that.
Because ultimately this
Understood.
cancellation order has come, Lordship.
Therefore, the speaking order has been put to challenge.
Yes,
The
yes.
moment there is a direction to pass a speaking order,
Yes.
the speaking order, the moment it is passed, your order dated 5/12 has merged with the speaking order.
Yes, yes.
So therefore, the first writ petition no longer remains.
Yes.
It is the second writ petition who has to remain. And you have filed an affidavit where? In the first writ petition.
In
Yes,
this-
yes.
The first writ, second writ petition, why haven't you filed your affidavit?
Well,
That was in second also.
second, yesterday I received a copy of the.
In the second writ petition.
Malad, we required to time to file reply.
So the first writ petition has become infructuous. We close the first writ petition, keep the second writ petition.
Item number 9 has become infructuous.
That is what. It has
Yes.
become infructuous.
Yes, yes. In item number 8, we have filed affidavit yesterday only, Lordship.
Malad, in fact, Malad,
You have filed the affidavit in 5611.
5611, yes.
So, okay, I'll give him the liberty to file a reply in 5611.
Malad.
But these 924/2025 do not survive.
Yes, yes.
Dekho. Heard Mr. in 924/2025. Heard Mr. U.K. Goswami, the learned counsel appearing on behalf of the petitioner, and so who appears on behalf of the respondent number
2, 3 and 4.
2, 3, and 4. It has been submitted by Mr. S.R. Borua, the learned counsel appearing on behalf of the petitioner, respondent number 2, 3, and 4. That the instant writ petition has become infructuous in view of the fact that pursuant to the directions passed in
That is annexer H, page Malad
passed
47.
passed in
Page 47, relevant person at page 48
passed
onwards.
in- Now, where is the requirement for passing a reasoned order?
Malad, page 50.
What is the date of the order?
That is 17/9/2024. Page Malad 48 onwards, Malad, 47 onwards.
17/9/2024 is in some other writ petition.
Malad, this, which is going to be disposed of by
It is
this.
9/24/2025.
Malad, the same issue, earlier petitioner is approached by way of filing 54999/2023.
Okay. Okay, 17/9/2024.
Yes, yes.
Submits that Mr. S.R. Borua, the learned counsel appearing on behalf of the respondent, number 2, 3, and 4, submitted that the order dated (21/10/2024). Order dated 5/12/2024, which have been assailed in the instant proceedings, no longer survives in view of the order passed on P6/2025, the learned counsel for the respondent number 2, 3, and 4 submitted that the order dated 5/12/2024 was passed without taking into consideration the order dated 17/9/2024 in WPC number 45499/2023. Taking into account the said submission, nothing further remains in the instant writ petition, inasmuch as the order dated 5/12/2024 is not being insisted upon by the respondents in view of the passing of the order dated
3/6/2025.
in 3/6/2025. Accordingly, the writ petition stands closed. Next chronological. Mr. S.R. Borwa, the learned counsel who appears on behalf of the respondent numbers 2, 3, and 4, submits that an affidavit in opposition has been filed by the said respondents yesterday, date to deliver. Mr. U.K. Goswami, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to file a reply. Considering the above, list this matter again on 21st of August 2026. In the meantime, the petitioner is granted the liberty to file reply to the affidavit in opposition filed by the respondent number 2, 3, and 4. The registry is directed to bring on record the affidavit so filed by the respondent numbers 2, 3, and 4.
Hello.
One thing, others may go, huh? Yes, what is this? I took this matter someday before.
Yes, it was heard extensively from the last occasion.
What is this? Election, Ken Chaudhary, how the brochure Abia would be applicable, taking into account that the petrol was set up sometime in the year Human in the year. Okay, this one. Dissolved by operation of law.
We have filed an additional affidavit to bring on record the matters that have come up.
We do one thing,
Be
we have
heard.
it on, are you going to do it?
Next day, Lordships.
You'll do it?
Next day, Lordships, a date may be fixed, Lordships.
Okay. We fix it on 4th of August.
Deeply obliged.
Taking into account the additional affidavit have been filed by the petitioner, this matter on 4th of August 2026. The export Thakur, you want to file reply against that?
No, I already filed, madam.
No, against that additional affidavit.
No, he's only brought me the brochure, madam. Not required.
One number, yes, what hearing is there? Will matter.
Lordship, and item number 10.
10. The new matters.
Yes, Your Honor.
What is this? What is your matter? 2010. Item number 10. What is your case?
Your Honor, it's regarding an NIT which is fishery matter, Your Honor, particularly.
Urgency.
No, Your Honor. Any date may be fixed, Your Honor.
You don't have urgency, then
Next week, Mala. Maybe next week, Mala.
stay.
Yes, Your Honor. There is an interim, Your Honor.
Okay.
There's an interim order.
Fishery matter.
Yes, sir.
Okay, list this matter again on 6th of August 2026 at 2 p.m. for final disposal.
Sixth, deeply obliged.
Deeply obliged.
Order is there.
Yes, Your Honor. There is a
Same order passed earlier, stand extended till the next date.
Item 11 maybe fixed on 6.
What is this? What matter is this?
Fraudulent transactions had taken place, my lord. The petitioner with lordship were the senior citizens. Petitioner before lordship, petitioners are senior citizens, my lord. Fraudulent transactions have taken place, my lord, from their bank account, by which certain.
But this matter has come up for hearing. Should have been done at the admission stage.
My lord.
itself.
It was listed for several occasions on admission column.
Huh?
It was
Lord,
listed,
this
but
counsel for the SBI was in between, they was not present, my lord. They filed the notice, again it was sent, notice was resent to the SBI. And then, my lord, yes, in the provision.
Senior citizen, we have to do
Yes,
something.
my lord.
And
On
one of the petitioners had died of.
6th of August.
Huh?
On 6th.
Just now I fixed, okay, 6th of
Well,
August at 2
6th.
PM.
My lord.
2 PM, ma'am.
Is the matter on 6th of August at 2 PM for final disposal. Was the liberty given to the petitioner? Take a 2 PM, full stop. The matter would be given more precedence, taking into account that the petitioners are senior citizens.
My lord.
My lord, my lord.
Obliged.